Yes.
May I seek your lordship indulgence in making a mention with respect to item number 18.
Item number?
18, lordship. 18, item number 18.
Okay. You don't want to do it?
Because lordship, my senior is getting married tomorrow.
Huh?
My senior Joseph Lelson Himarentle is getting married tomorrow. And
Tomorrow?
he has, yes, tomorrow, my lord. He has submitted his leave of absence to lordship.
What do you say, Mr. Malhotra?
It's okay, Lordship, since he's getting married tomorrow.
Tomorrow, I don't know. I may not be sitting out here tomorrow. I mean, I'm not taking. 16 and 17, I can't take
You
it.
can't take up yours.
16, 17, not before me.
Will it come up after a week?
Lordship, if this matter may come up after three weeks, if possible.
2 weeks.
After 3 weeks.
3 weeks. Okay. At the request of the learned counsel appearing on behalf of the respondent, matters that adjourned be listed after 3 weeks.
I'm obliged.
Much obliged.
For motion, item number 1.
My lordship, I newly received instruction, my lord, to appear for the petitioner herein, my lord. So, even as I already submitted my vakalatnama, my lord, it's not yet been reflected in the cost.
What are you
list,
challenging?
my lord?
What are you challenging?
Actually, my lord, since I'm not aware of this matter being listed in which I'm involved, my lord.
We are challenging a granting of bail.
Granting of bail, my lord.
Why?
That, my lord, I have to go through the brief, my lord, still. So for
You are
that, my
not
lord,
going
if,
to- first and foremost, how can you challenge it? Have you filed an application for cancellation of bail before that authority, before that court?
the same court, my lord.
Yes. You should have
That-
asked for filing an application for cancellation of bail there.
Apologies, my lord, I'm not aware of any,
That's the law. If a bail is being granted,
my
you
lord.
have to first approach. Against that, a revision will lie.
That I'll have to look into, my lord. So for that, my lord, if this matter may kindly be listed to tomorrow or day after tomorrow, as per the lordship's convenience, I'll go through, my lord.
But your petition is not maintainable.
In that case, my lord, it will go. But if not, the matter may kindly be granted, my lord, for tomorrow. It may kindly be listed tomorrow.
408, 467, 46. Where is the order? Order of granting bail? What is wrong with the order?
As I, lordship, have submitted, my lord, I have submitted that I have not yet gone through the brief also. Since
Go through it.
yeah, I'll go through, my lord. And in the meantime, my lord, if the matter may kindly be taken up as per lordship convenience tomorrow or day after tomorrow, or
And you are, who is the Mahindra and Mahindra
I'm
Financial?
appearing for Mahindra. Lord.
And the state has not filed any application. Then how is it at all maintainable? You should dismiss it right away now. You are appearing for whom? State?
For the state, my lord.
Yes. State has no objection.
No.
It's a case. It is against the state. Then
Yes, my lord.
the law is very clear. If a bail is being granted, you have to file an application for cancellation of bail there. You can't
For the
file
same
it
court.
here. It's after all, it's a right under Article 21.
I'm only taking over the brief only recently, lordship. I took over the brief only recently, so I have no time to
Your
go
name
through
is there. You filed this application.
My name, my lord, also is not reflected therein in the cost.
Are you the counsel out here?
I'm the new counsel, my lord. The newly engaged counsel, lordship.
The matter has come earlier it had come up on 12/9.
That I'm not aware, my lord. Since
12:09. Okay, you look into it, we'll take
I'll
it
look
up.
into it, my lord.
We'll take it up at the last item of the day today.
Today, my lord.
Yes, today. How much time does it take for you to go through it? It's a small matter. Cancellation of the bail.
Tomorrow, my lord.
It's tomorrow. Tomorrow, no. Matters should not be prolonged for long.
Yes, yes, yes. I see.
Better off, why don't you file an application before that court for cancellation? Because if I dismiss it,
My lord.
then your application for cancellation also goes for a miss. So think about it.
My lord.
We'll take it
Tomorrow.
at the today, last item of the day.
Today, my lord.
Today, last item of the day. The only thing which you need to think about is whether the bail application should be, you will file an application for cancellation of the bail before that court, or you take an order on merit out here dismissing your application, and thereby you can't file that bail cancellation there also. Keep your options open
My lord.
as the last item of the day.
My lord.
For admission, item number 2.
This item number 2 is some writ petition. This is an FAO. This is item number. Where is it? Oh, give me a wrong. Okay, this. How much is the delay?
My lord, 21 days.
131 days.
Yes, my lord.
Hmm?
131 days delay.
Which order you are asking for setting aside? FAO. You are challenging this order in an FAO. How is an FAO maintainable? Forget about the limitation. Limitation will dismiss it right away. How is your FAO maintainable? FAO would come, you are filing this appeal. Under what provision?
My lord,
As per the CPC? Is CPC maintainable, applicable out here in the state of Mizoram?
yes, my lord.
And if that be so, an FAO will lie under 104. You are challenging this order of 6/3/2024,
Yes, my lord.
isn't it?
Yes, my lord.
This is an order by which your application for setting aside or for dismissing of the suit was rejected, isn't it?
Yes, my lord.
So under such circumstances, if this application would have been allowed, a revision will lie at best under 115. But how is an FAO maintainable?
My lord, according to our research, in our opinion, under Section 96 CPC 9 1908, with Section 17 Clause to subclause B of the Mizoram Civil Act.
This appeal is directed against one. How is your appeal maintainable under 96? First of all, it can't be an appeal. The suit has not been dismissed. So there is no decree. So it can't be an appeal under 96. Okay?
Yes, my lord.
It can't be an appeal under 104. Because 104, if it is so, then you have to take into account order 43 rule 1R. 1. Because 104 categorically mentions that it is only in respect to wherever the court categorically mentions where an appeal is maintainable. And this application for rejection of the claim under 83 does not arise, come within the ambit of that. So how is the affair maintained? It will at best be a revision under 115. You have the CPC with you?
Not yet, sir.
Where is the CPC?
Not yet, my lord.
Huh? Anybody has a CPC? Give it to him. Yes. See, C96. You have filed this appeal under 96. It can't be an FAO. It could have been at best nomenclated as RFA. But 96 will be only against the decree. Isn't it?
Yes, my lord. And my lord, can I have a submission regarding this appeal? If this FAO cannot lie under section 96 of CPC,
It can't come under 104.
if this honorable court permits the amendment of the petition.
No, there is no amendment here. Here you have to withdraw and file an application for review under revision under 115. If you are agreed with this order, very well. You have to file an application under 115. You can't convert this. Isn't it?
Yes, my lord. My lord, can we have further time for
For what? Your last item? Last but one?
no,
Can't go by beyond today.
not on today.
These matters can't go beyond today. It has to go by last but because the last item that other council has already taken. Item. So you will be the penultimate. Okay. I'm giving you a good suggestion, therefore. You want to challenge it, challenge it. There's no quarrel with that. You have to do it under 115.
Under 115.
115. See 115.
Then can we refile the FAO
Huh?
with another petition? Can we refile the FAO?
That is what I will
Yes.
allow you to withdraw with the liberty to refile by way of filing a
Yes,
revision.
my lord. Yes, my lord.
That is how you file it. If you want to file, you cannot, the appeal does not lie against an order passed under, whereby the suit has been held to be maintainable. It can either be by way of a revision or by way of a Article 227. So under such circumstances, you need to withdraw and refile it, which I am giving you the liberty to do so. But you have to file a 115 or 227.
Yes, my lord. Today I I pray for withdrawal with liberty to fresh file
Yes,
to
better
file a
off.
fresh petition. Yes.
Much better. Therefore, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. the present appeal has been filed challenging an order dated 6/3/2024 passed in money suit number 137/2023, whereby the court of the learned civil judge, senior division number 3, Aizol, have rejected the application filed by the appellant for dismissal of the suit, for rejection of the plaint. Full stop. The learned counsel appearing on behalf of the petitioner upon perusal of the provisions of law, and more particularly section 96 and 104 of the Code of Civil Procedure, read with order 43, submitted that the petitioner appellant ought to have filed an application under section 115 of the Code of Civil Procedure, or 115 of the Code of Civil Procedure, inasmuch as if the application so filed by the appellant before the trial court would have been allowed, it would have led to the disposal of the suit. He therefore submits that he may be permitted to withdraw the instant appeal and file an application, and liberty may be given to file an application under section 115 of the Code of Civil Procedure 1908. Taking into account the said submission, this court, while taking up the application for condonation of the delay, allows the withdrawal of the application for condonation of delay as well as the accompanying appeal, thereby granting the appellant the liberty to file an application under section 115 of the code, subject to the same being permissible and maintainable in law.
11.
Item number 3 and 4.
Lordship, he is also my lord. He is similar,
What?
my lord, similar Mahindra case. Here also my lord. And actually my lord,
What are you
up
challenging?
till item number
439 application under
item number 9, my lord.
order passed by the so and so in anticipatory bail. Right. Yes.
This is regarding the anticipatory bail order, my lord, passed by the session judge.
Same person.
Same. No. They are all
Another person.
different persons. Your lordship.
Now, here, Mr. Malhotra, you are appearing for?
For the respondent number 2, Your Worship.
For that, my lord, if I may kindly be allowed time till tomorrow, my lord. Because now the same will go on till item number 9, my lord. They are all similar cases. Item number 9, my lord, today. They are all
Connected matter.
connected matters, actually.
Item number 9?
My lord.
5,
Ah.
9 also. 9 is what? That is a criminal, these are all criminal petitions.
No, my lord. Item number
All these matters, 6, 7.
5, 6, 7, 8, and 9.
So good. All these matters.
If
Yes,
we can,
Mr. Malhotra.
can we
Is
kindly
it
take it?
permissible to file an application before any other court other than the court where the bail
Bail was
application
granted. Your Worship, Your Worship, I agree with Your Lordship's statement that unless he approaches the court which
Yes, he has
granted
to
the bail
approach
first,
there.
then if that is rejected, they can come up in revision or 482, whatever. in her-
Then whatever he may, he can come up. Can't come up before this court under 482,
Directly.
439-2. How can this 439? The bail was granted by that court.
The problem now, my lord, as I submitted is, since I have not all gone through, my lord.
Huh?
I have not gone through, my
The
lord.
old matters. The first one was the new. So now, all
Now
these
it will build up.
items will
I wouldn't be having
taken
time, my lord, actually today.
at
So,
the last item of the day again.
but my lord, yes. In the meantime, my lord, I won't be having time also even to go through all the files, my lord. So for that, my lord, if I may kindly be granted tomorrow, my lord, till tomorrow.
Tomorrow what?
And tomorrow
What
it
are
may
you going
kindly
to
be
do with
listed and
tomorrow?
then whatever happen,
Yes, who
happen.
is appearing out here in video
Let them-
conferencing?
That's my only prayer, my lord.
Huh?
My only prayer is that let the matter may kindly be taken up tomorrow, my lord.
Why? Today?
No, my lord, now I have this much cases, so I only received the brief only today, my lord. So how can I?
Why are you not filing an application under 439(2) there?
That's my prayer, my lord.
Okay, but the thing is, today or tomorrow the weather may change.
No, no, no.
The clouds will go away.
Let whatever happens. It's up to your lordship. But now my only prayer, my lord, is that let the matter may kindly be taken up tomorrow. That's all, my lord. Now my name also has not been reflected even in the cost title, cost list, my lord.
You have not signed your wakalat number?
Vagarat already filed with the registry, but it's not
Where?
listed today.
What's your name?
C. Zoram Chana, my lord.
Oh,
So it's not here even the cost list, my
you
lord.
filed your wakalat number on 4th of October.
Yes, I already filed it, but the brief I have not been furnished, my lord. So, and now also, my lord, when the
20
cost list
days,
came
you
up, my
filed
lord,
the
I am not
wakalat
aware of the cases being
You
listed today,
filed
my
the
lord.
wakalat number 20 days back. I think you were ready with the matter.
No, my lord.
No?
So, and the matter, my lord, another problem is that since I am not aware that these matters are now listed today, my lord, that I'm not aware. Only this morning, my lord, that since my name has not been listed, so
From this 4 to 9 and item number 1. All these matters tomorrow.
tomorrow, my lord.
Okay, tomorrow.
Deeply obliged.
You get the judgment, Justice Nagaratna's judgment, where it categorically mentions that you cannot file an application for cancellation of bail before the High Court unless you move to the trial.
Forward is item number 10.
Seven?
May it please your lordship.
What is this?
My lord, this is an application for condoning 90 days delay in filing the connected appeal.
Donation.
Yes, my lord.
NDPS.
And the NPS Act, my lord. The applicant/appellant was convicted by the Additional Sessions Judge Kolasip for 5 years of rigorous imprisonment with
Who is
fine.
paying for Mizoram?
My lord, I'm appearing.
How much is the delay? 90 days.
90 days, my lord.
Ah, we
I
condone
will have
it.
no objection. Yes.
We condone this.
All right, my lord.
I will
Lord,
begin.
if I may interfere, lordship, regarding that item number 3 to 9, my lord. If my name may kindly be reflected in the cost list tomorrow, my lord. That's my prayer.
I hope you have a good memory by tomorrow. You won't forget. These are the matters to be taken up.
No, my lord.
Don't worry. Tomorrow it will be there. I'll reflect your name categorically with golden letters on top when I pass the order. Don't worry. Mahendra and Mahendra is absolutely within your domain. Heard Mr. So-and-so, the learned counsel appearing on behalf of the applicant. Ms. So-and-so appearing on behalf of the respondent number 1 and 2. This is an application for condonation of delay of 90 days in preparing the connected criminal appeal filed under section 4152 of the Bharatiya Nagarik Suraksha Sanhita 2023, read with section 36 capital B of the Narcotic Drugs and Psychotropic Substance Act 1985 against the judgment and order dated 17/5/2024 and as well as the sentence order dated 22/5/2024 passed by the learned fast track court additional session judge Kolasip district Mizoram in SC bracket K number 6/2023 whereby the applicant was convicted under section 21 small b of the NDPS Act 1985 and sentenced to undergo rigorous imprisonment for a period of 5 years with fine of rupees 5,000. Full stop. This court, upon hearing the learned counsels appearing on behalf, this court have duly perused the application and have also heard the learned PP who submits that she has no objection in respect to the condonation of delay. Accordingly, this court allows the instant application, thereby condoning the delay of 90 days in preferring the accompanying appeal. I stands disposed.
Deeply obliged, my lord.
Wait, let's take up the next one. Yes. Let's admit the appeal.
Yes, my lord. My lord, in this case, the majority of our grounds, they stands with the procedural lapses. In our ground, my lord, we have stated that there is a violation of Section 50 of the NDNPS Act. We have also stated that there are procedural violations under Section 100 of the CRPC, and we have also stated that conscious possession is not proven. And we will also be stating that there is non-compliance of Section 52A of the NDNPS Act.
Okay, we admit this thing, but you have not filed an application for bail.
Not bail, my lord.
You want to be inside?
Sorry, my lord.
You want to be inside?
No, my lord. No, my lord.
Fantastic. But for that,
Usually here in
for that
Aizawl,
you need to file an application for bail.
yes, my lord.
Then-
But we have not filed.
Okay.
Usually here in Aizawl, my lord.
We give you
Unless-
the liberty to file.
Yes, my lord. I will be deeply obliged.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the appellant, and Ms. So-and-so, the learned counsel appearing on behalf of the respondent number 1 and 2. This is an appeal filed under section 415, bracket 2 of the Bharatiya Nagarik Suraksha Sanhita 2023, read with section 36B of the Narcotic Drugs and Psychopathic Substance Act 1985 against the impugned judgment and order dated 17/5/2024 passed in by the Court of the Learned First Track, Court of the Learned Additional Session Judge Kolase, Mizoram, in SC bracket K number 6/2023, arising out of CRL.TR. bracket EX number 3/2023, whereby the appellant was convicted under section 21 bracket B of the bracket small b of the NDPS Act 1985. Full stop. The appeal is admitted. Call for the records to list the matter for hearing immediately upon receipt of the records. Full stop. The petitioner, the appellant, is given the liberty to file application for bail if so advised.
Deeply obliged, my lord.
Item number 11.
What is this?
My lord, may I please lordship? This is an application for impleadment of one Mr. Rokunga Chungte, who purchased the disputed landed property covered by LSC number 52 of 1996, my lord, during the pendency of the suit. So
During the pendency of the suit or in the appeal?
during the pendency of the suit, we were not aware of that.
You came to know at the time of
We
the
came to
filing
know
of the-
only when this honorable court allowed us to have to make an effort to have settlement outside the court, my lord. We came to realize that the respondent is no longer the owner of the disputed land, my lord.
You realized only in the appellate stage.
Yes, my lord. So we have collected certain documents from the revenue department. We have
But why are
annexed-
you making him a party?
my lord. let
Why
him-
are you making him a party? If he has purchased during the pendency of the suit, it is his
that we
responsibility.
didn't know that, my lord.
So therefore, it is his responsibility to come before this court.
My lord.
You see, if you today make him a party out here,
My lord.
he will come up with many defenses. Why do you want that? Is that person not bound by the decree which will be passed? Because this happened during the pendency of the suit.
That is true, my lord. The problem is, my lord, we didn't know that he
Understood,
purchased.
you didn't know, very well, but this was sold during the pendency of the suit.
Yes, my lord. During the pendency of the suit, I said, because on cross-examination of the respondent number 1, who was the plaintiff of the instant suit before the civil court, my lord. He, on his cross-examination, which we came to learn only recently, he admitted the fact that he sold the landed property covered by LSC number 52 of 1996
Where?
to
In the trial court.
in the trial court, my lord.
So then why you want to make him a party here?
Because the issue with regards to the ownership of the said LSC is here for this honorable court to consider, my lord. And that is why his presence
You
is
were the
required.
plaintiff.
I am the defendant, my lord.
You were the defendant.
Yes, my lord.
You sold the land to somebody else.
The plaintiff sold the land to somebody else. Somebody else means Mr. Rokunga Chungte, who was not a party to the present case.
You were the defendant,
I am the defendant, my lord.
and the suit has been decreed against you.
Yes, my lord, against us. And that's why we filed the present appeal, first appeal.
So you want,
We want him to be a party.
but he has to be transposed as a appellant.
Yes, my lord, it was the duty of the respondent to inform the court that he has already sold the land, but he has not done so. We came to realize that it was sold to him only when we made an effort to settle the matter
Let
outside
us
the
see
court.
the
my lord.
judgment. This is the judgment.
Yes, my lord.
Where is the judgment? Passed by the learned trial court.
The judgment is found at my
It
lord.
is civil suit number 2.
Yes, my lord.
Now, 1 and 2, they have sold this property to the third person.
Yes, my lord.
And you are number 5.
I am the number
Plaintiff-
5 and
plaintiff
6,
number
my
fi-
lord.
defendant
I am
number five.
number 5 and 6.
You are
Defendant number 5 and 6.
defend number 5.
5 and 6, my lord.
5 and 6. 5 and 6. Okay. You were defend number 5 and 6. Now, where's the decree? Judgment?
Judgment is found at page 187, my lord. Judgment 187.
Page?
Page 187 of the paper book, my lord.
7.
187 is the impugned judgment and order passed by the learned senior civil judge.
So the decree is passed whereby the plaintiff's right title interest has been declared in respect to the land.
Yes, my lord.
Now, the plaintiff has sold this land during the pendency of the suit
Yes, my lord.
to somebody else.
Yes, my lord. To Mr. Rokunga Chungte,
Okay.
my lord.
Now, why being a defendant, you want to implead the plaintiff, the third person whom the plaintiff has sold.
The reason being
Because
that,
you see,
my lord,
don't you think that the provision of Order 22, Rule 10 will come into play of the CPC? It is for them, that person,
my lord,
who now has an interest over the land in question. Because you are not the plaintiff,
yes, my lord.
who has now the interest of the heir to defend this judgment. It is not you who is going to tell him, kindly defend.
My lord, problem with us is that we want to have a amicable settlement with the plaintiff, respondent herein.
Because there are many judgments of the Supreme Court, if you see,
My
in
lord.
respect to Order 22, Rule 10,
My lord,
that it is for him to come before the court
my lord,
if there is an assignment or a transfer during the pendency of the suit.
my lord.
It is not
That is
for
true.
you. Why will you out here? Yes, it's a case of
That is
very
true.
good fairness
But
on
my-
your part. But the CPC doesn't work in that manner.
My lord, that is true, very true. However, my lord, as for us, since we want to have amicable settlement with our
But
neighbors,
it is for them. If they don't protect themselves,
that is
very
also
good.
true, my lord.
You don't have an opponent against you. Good, very nice.
If we realize that he was the owner of the disputed land long time back, we could have settled the matter outside the court with him. However, we didn't realize that he was the purchaser who purchased the land from the respondent number one. Then problem cropped up that we could not settle the matter
But it is
outside the
for
court.
the plaintiff to
Very true, my
inform
lord.
them, inform the third party, kindly go and appear before that court or do whatever, or pay the fees of the client, of the lawyer. But you want that he should also come.
Anyway, well, my prayer is for impleadment of the.
Because you see, why I'm saying so, the moment you are impleading him,
My lord,
the question is, he will have a different defense.
that
He will say that I am a bona fide purchaser
right, my lord.
without notice about the suit.
That is true, but
Things will come in.
at the same time, my lord, that is not a problem for us. That is not a problem for us. We can settle the matter
Because
with
he
him,
is asking for the right title interest.
my lord.
The plaintiff is asking for the right title interest.
Right.
It is not for the defendant. You are only a defendant.
Yes, my lord.
That right title interest, the decree which has been passed,
My lord.
you are challenging it out here in the first appeal.
Right, my lord.
Once you are challenging, you get it set aside. The plaintiff loses the right title interest. It is not a case by which, on the basis of a debt of some defendant or some plaintiff
Well.
who now happens to be the respondent, you are to bring him
Well.
by way of substitution. This is not the case. This is a case of an assignment under Order 22, Rule 10.
Right.
So
my
it is for them to come up and see, we want to protect the decree which has been passed in our favor.
my lord, anyway.
There's absolutely on this point, there's a judgment of the Supreme Court. I think Dhurandhar Singh, you have a look at it. It categorically says it is he who has to come. Not you are not going to come in.
Right, my lord. The respondents are here through their respective counsels if they want to file objection, things like that, my lord.
My lord, we just received the application today itself.
Huh?
My lord, we received the application for impleadment today.
You are
itself.
for?
I'm for the respondent,
Respondents means the plaintiff.
the plaintiff in
yes,
the.
Plaintiff. You
my
should
lord.
be happy that the senior counsel is doing your work.
But I am the
In fact,
appellant, my lord, in the.
this application should have come from your side. That look here, we have now sold this property to so and so. So kindly bring him also out here, which he is doing. You should be happy.
Right, my lord.
We pass an order in terms with Order 22 Rule 10
My lord.
and make him a party
Right, my lord.
in terms of on the basis that he has. Now you have sold this land.
Yes, my lord. But my,
Have you sold this land or not? Have recently come to know that one Rompu Chungti had purchased all the disputed LSCs registered in the various names of the plaintiffs. Besides this, by the letter dated
yes, my lord. As
issued
per
by
the annexure, we may
ownership
have
of 52
sold the
had
land.
already been transferred to the name of so and so, by so and so. Instead, Mr. He is a necessary party and it will not be proper for the court to hear the matter pertaining to his LSC in his absence. Now, when was the suit filed?
Suit filed way back in 2000, my lord. 2009, my lord.
And the transfer happened?
Transfer happened in 2011, my lord.
Kindly come to page 4 of your application. Of your application, kindly see the disputed LSCs registered in various names of the plaintiff.
Transferred in by this order in
Besides this,
2008,
the
my lord.
letter dated had duly so and so, the ownership of the has been transferred in the year 2008.
80s, my lord.
So this was prior to the suit being filed.
Yeah, prior to the suit being filed, my lord. Right. We were not aware of that.
Then how did the plaintiff have a right title interest over the land?
That I don't know. He filed the civil suit himself on the basis of this LSC.
Understood.
My
But
lord,
if
along
he
with
had
others.
already sold it prior to the suit being filed,
Right, my lord.
then how
There
does
are,
he have any right title interest?
my lord, there are 13 LSCs. There are 13 LSCs on which, on the basis of which the present civil suit was filed by the respondent number 1, a plaintiff. And this LSC, which was sold by him to one Rokunga Chungte, was one of them.
Only one person was sold.
Yes, my lord.
Not all.
One LSC was sold.
No, not all LSCs.
Not all LSC at that point of time.
Okay, only one LSC disputed registered in various names. Here you say that all the disputed say
All the
purchased
disputed-
all the
Yes,
disputed LSC.
my lord, we came to learn this particular LSC 52 of 1996 was sold in the year 2008, whereas the rest of them were sold, we came to learn, during the pendency of the present appeal.
But it is not mentioned anywhere.
It is not mentioned, but
Then how do we gather it? Because if that be so, the
My lord.
plaintiff loses its right to the right to file suit.
my lord, this
he has sold it.
once the
We do one thing, Mr. Counsel, we issue notice
my lord,
because they have to reply to this.
Right,
because
right,
this
right,
will
fine.
otherwise have
Let
a
them.
strong, will have an impact on the plaintiff's right to sue if
Right,
he has
right.
sold. Because your
My lord,
specific
my-
statement is, had purchased all the disputed LSCs.
Right, my lord.
If it is purchased by all the disputed LSCs, then the
My lord.
plaintiff did not have a right to sue
right, very true, my lord.
because he did it in 2009.
My lord. So let them file written
Okay, we
objection.
issue notice then.
My lord.
A condition. This is an application filed by the appellant to implead the subsequent purchaser of all the LSCs of the plaintiffs on the basis of which title suit number civil suit number 2/2009 was filed. Issue notice making it returnable on 14th of November 14th 2024.
My lord.
Ms. So-and-so appears on behalf of the respondent number 1 and 2. Mr. Counsel, there is another big problem. You have not made him a party whom you want to implead.
That is why we have filed the present application for impleadment of the new party, my lord.
Understood, but here you have to make him a party now. In this, don't you think so?
In this IA, yes, my lord, this is the way it should
Where have
be.
you made him a party? You should have made
For
him
making
a
him, my lord, for making him a party, we have filed the present application.
Understood.
My
You
lord.
want to make him a party in the RFA,
Right, my lord.
for which you have filed this application.
My lord.
Tomorrow, if he wants to say something,
My lord.
how will he say? He's not a party. I can't issue notice to him. Can he come up and say that I have not purchased
Right,
it?
my lord. If my present application is allowed, then he will be made a party.
Understood, but
My lord.
is this court going to pass an order in his absence, whom you want to bring him and making an allegation that he purchased everything? Tell me.
My,
How
on the
do you
basis
make
of this
him a
application, my lord, he will be made a party since making him a party is
you
up
have
to
to
the
make
court.
him a party also, don't you think so? Because if you don't make him a party, tomorrow he may say that I have nothing to do with this property.
My lord.
Then how do you take care of it?
That is also true, my lord.
Huh?
However, my lord, the practice out here is
you want
this
to give
way.
him all the fairness, asking him, let him represent the state, the hearing on behalf of the plaintiffs, everything, but you are not making him a party here.
My lord, for that purpose only, we have filed the present application for implement of the new party, my lord.
Now then, why don't you file a fresh one?
First one, we can do
I
that,
think
my lord.
instead of that, again, you amend it. It will take a long time. So
My
why
lord,
don't you file a
We
fresh
can do that,
one
my lord.
and make it under Order 22, Rule 10?
My lord,
And
my lord.
also,
Then I may be permitted to withdraw the
yes,
instant
and
application,
take
my
into
lord.
account the judgment of Dhurandhar Singh, which I am informing you, 2001, I suppose. Just I'll give it to you. Wait. Have a look at this judgment. This is, I think, exactly on that point. Yes. 2001 6 SCC. Five three four,
Yes, my lord, noted.
and you get this exactly this aspect, which I say to you. Paragraph 26. Yeah, paragraph 26 categorically mentions this. It is actually the duty of the plaintiff. And otherwise, that person also, the person upon whom the interest has devolved, may also apply for such leave so that his interest may be properly represented as an original party. Have a look at this. I
My
think
lord, I'll
then
do
you may not even require
My lord, my lord.
so-and-so, the learned counsel appearing on behalf of the appellant, submits that that in view of the fact that there are certain formal defects in the instant application, he may be permitted to withdraw the instant application with the liberty to refile if so advised. Who's taking into account the above, the instant application stands closed on withdrawal. However, the appellant, like the applicant, would be at liberty to refile by removing those formal defects.
Obliged.
But I don't think you will require in view of that judgment.
My lord.
Paragraph 26.
I'll think about it.
Item number 12, 13, and 14.
May I please your lordship?
Yes, tell me.
This IA numbers 174 of 2024 is an application for impleadment of the present incumbent of Deputy Commissioner of Longtai District, since the previous incumbent has been transferred out from the said post.
Did
The
the order pass in the contempt? Why you have filed the contempt?
contempt,
Why have you filed the contempt?
my lord, in the main writ petition, in the connected writ petition, there is an order passed by this court on
Where is the order passed by?
page number 13, my lord, 13, page number 13. Annexure 2 from page 12.
19/7/2019.
19/7/2019, my lord. On the relevant portion is on page number 16, 16.
Status quo as on today shall be maintained
Yes,
by
my
the
lord.
respondent. That's
Yes,
the
my-
order.
Yes, my lord. In spite of this, my lord, they have made separate award without taking the leave of the court.
Huh?
They have made another award
Another award.
for payment of compensation without taking leave of the court.
Who has done it?
The DC of Longtai
So
District.
how can the new DC be made a party?
My lord,
He has not done that.
as of now, my lord,
Isn't it a contempt of quasi-criminal proceedings? You do it only against the person who has done it. How can you keep on making parties after parties who has not done anything?
if
Let us also be knowledgeable. How is it possible? There was a direction
to maintain
having
status quo.
regard to the projection made by the petitioners, it is hereby directed that till the next date, the status quo as on today shall be maintained by the respondent.
Yes, my lord.
Okay. Now what has he done?
They have prepared on the next page, my lord,
Hereby did to represent the undersigned, approval of their draft award, division and amount to be paid, summary.
they've made this draft
Has
award.
the
number-
award been passed?
Yes, my lord, 1 of 2019.
Huh?
Draft award number 1 of
No,
2019.
the draft award is
No,
different.
after this, they have pronounced, approved, and disbursed to some of the landowners.
Where?
At the time of filing the contempt petition, my lord, they have not yet disbursed, but during pendency of the contempt petition, it was already disbursed.
Where is the award?
It's here in page number 21, my lord. In the contempt petition, my lord, page number 20, if I may take a lordship to page number 20. Letter dated 27th September 2019. This is the approval of the said award, which was made in defiance of the interim order.
The council,
Yes, my lord.
21(8), that order for which you have filed a contempt
Yes, my lord.
categorically mentions that the interim order shall be the pendency shall not be a bar to pay compensation to the petitioner in terms with this. Then the interim order was passed where? Which case?
In the connected WPC number 90/2019.
90.
On the first order, while issue notice.
90. That is 19. So having regard to the status quo, interim order here, interim order to continue. is the next date. Tell me, Mr.
Yes, my lord.
Counsel,
Yes, my lord.
in view of the order passed on 8/12/2021,
812.
in writ petition number 90/2019, how does the contempt proceedings remain any further? Because the award which was being passed, there is now a modification to that order, and there is a direction now to disburse to 138 persons which have been found to be
No,
genuine.
that is different thing, my lord. Prior to this 138 issue came.
Huh?
Prior to this issue of 138 came, my lord. The question of this order, disobedience of the order.
But as of now, don't you think that this court had already modified that order?
In respect of 138,
Understood. So that has already been
We are-
modified, and thereby giving sanctity to the award which was passed subsequent to the passing of the interim order.
my lord, there are two awards after this filing of this case. The one is which is under contempt, and this 138 is different thing.
This is the same case where this order is
It
being
is the
passed.
same case, but leave is granted only for this 138, which we are not aggrieved to it. This award number 1 of 2019, in which contempt has been filed, is different award.
Is it different?
Yes, my lord.
No, the draft award number, Iman, as many as 138 of the land parcels have been found to be genuine after due examination and AR conduct.
Yes, my
Now,
lord.
what is your cause of action for the contempt?
The
That there
award,
was an award passed.
that is different award, my lord, before this 138.
No, this is the order which is on the basis of which, this is the case on the basis of which you are filing this.
Correct, my lord, correct, my lord. But this 138 is with the leave of the court. Prior to this 138, my lord, this 138 has also not yet been
So
paid.
you are saying that they have passed the award without the leave of the court? Is
They
that
do
the
not have
case?
leave, they do not have leave of the court to pass that award, my lord.
Huh?
They do not have leave of the court to pass the award.
Understood, but they have passed the award or not?
Yes, they have passed.
Understood, but who has passed the award?
The deputy commissioner.
The then deputy commissioner.
Yes, my lord, the then deputy
Now,
commissioner.
why do you want to implead this present one? He has not done anything. That is my question.
I understand
He
that,
has
my
not
lord.
done anything. If he has done anything, okay. But he has not done anything. Somebody has passed an award in violation to the court's order. But that is that person who has done it. You don't make the office a party. You make the individual a party in a contempt proceeding.
Yes, my lord.
So how is this individual involved, the present incumbent? Tell me.
In fact, my lord, sometime it has been,
Understood, but when there is another aspect, but here the violation has already taken place way back. Rightly or wrongly, the violation has taken place. For that, those persons concerned would be liable. But how is this present deputy commissioner, who has nothing to do who has nothing, not passed an award, not done anything, how is he anywhere liable? Tell me. Now, once the award is being passed, the award is being passed on the basis of what? An award is passed on the basis of an approval given by the government.
Yes, my
Government
lord.
is to approve it.
Yes, my lord.
Now, once the approval comes, the award is being filed by the Deputy Commissioner under Section 12(1) of the Land Acquisition Act 1894.
Yes, my
So
lord.
once that is being filed, it then becomes a conclusive evidence between the Deputy Commissioner and the persons interested. That is one act which has already been completed. What is the role of this present Deputy Commissioner? Give me a good, fair understanding of that. Yes, Mr. Malhotra, you are also there. I've seen in one of the petitions.
So long as this case is pending, my
How
lord.
is it possible to make him a party? This is absolutely a person who doesn't arise. Understood. The practice is when there is something which has an order being passed and the mandamus is in effect being not complied with. But once the mandamus has already been, or any restraint, here is a mandamus by which there is a restraint order. But once the restraint order has already been violated by A, can you make C, who has nothing to do with A? Not possible.
My lord, I have.
Tomorrow, just for example,
Yes, my lord.
there is a mandamus passed by this court saying that, look here, the Deputy Commissioners pay Mr. Malhotra 4 lakh rupees. Let's take an example. The Deputy Commissioner does not pay this one. Next comes another Deputy Commissioner. He is also not paying. Then you keep on making them parties. But here is a case where the violation has occurred by some other Deputy Commissioner for whom he is already a party. How is this present Deputy Commissioner concerned?
If I may be allowed to withdraw the same
Huh?
in that case, my lord, since this is a practice here,
Because
so
of
long
that-
as
No, Mr. Counsel, that is why I'm saying.
Yes, my
because
lord.
of all type of filing of these type of applications, your adjudication of the actual contempt matter is getting delayed. You
that
keep
is
on
true,
making
my
them a
lord.
party unnecessarily,
That is true, my lord.
which would result at a later stage, you issue again notice to him. He appears through another counsel. They keep on appearing. Again, he gets shifted. You make another.
Exactly.
And at the end of the day, your contempt case would never get disposed.
That is true, my lord. But sometimes we were informed, asked to file the new, impleading the new incumbents one after another. That is the reason why I filed this
You explain
application.
to him with the example which I have given,
I understand, my lord, I got your point.
that when the Deputy Commissioner has been directed to pay Mr. Malhotra 4 lakhs, and the Deputy Commissioner doesn't pay, the next Deputy Commissioner comes, he is also bound to pay.
I will not
But
press on
when
this,
it
I
is
am,
a
my lord.
case, when the Deputy Commissioner has been asked that don't pay to Mr. Malhotra 4 lakhs, and the Deputy Commissioner pays that, then the next Deputy Commissioner cannot be involved in the contempt because the violation has already been done. These are the two contrasting examples. So explain it to your client.
Yes, my lord.
Withdraw.
Yes, my lord.
Yes.
My lord, if I may. My lord, I have prayed
We
to
are
this
taking
honorable
up
court
today
to.
that
Yes, my lord.
you want the final disposal of the petition. I'll be
No, my
happy.
lord,
I have no work today.
contempt petition, my lord.
Ah.
Contempt does not lie anymore, my lord. According to, I have already filed my affidavit, my lord.
Let us argue on the writ petition.
Writ petition, my lord, the CGC has yet to file her affidavit in the main writ
These
petition.
are old matters, 2019 matters. We have around 400 matters already in the insolvents and we have not filed.
Union of India was not part in that contempt case. However, we are impleaded, that is Ministry of Road Transport and Highway. Then I received
You
instructions.
see, I'm telling you one thing.
Yeah.
if there is a question, I don't understand why these type of writ petitions are pending. These are being done under the National Highways Act, if I'm not wrong.
Yes.
National Highways Act, more particularly if you see section 3G. 3G gives a particular method by which if you are aggrieved with the quantum of compensation, you can go into that. 3H is in respect to the person who is actually entitled to the amount. He can very well file an application before the district judge who can decide that. More particularly section 3H4. So if that be so, why are these writ petitions pending? It is for that court. How will anybody decide? How can this court, writ court, decide that he is a genuine person? That person is a fake. Tell me.
This acquisition,
The learned counsels for both the writ petitioners, tell me, have you looked into the section 3H4
my
of
lord,
the National Highways Act?
this acquisition is proceeded under the LA Act of 1894. This particular,
This is done for the national highways?
no, my lord.
This
It's
is for
under Land Acquisition Act 1894, the acquisition process.
This is done under 1894.
Yes, my lord.
Okay, you have that act with you?
Not right now, my lord, but at the same time,
Give him the Land Acquisition
madam.
Act of 1894. Have a look at it. See section 18.
yes, my lord.
Yes, please read it. Whenever a person is aggrieved, a person interested is aggrieved, as regards the quantum of compensation, apportionment of the compensation, entitlement of the compensation, he has to make an application before the collector in terms with section 18.
Correct, my
Okay.
lord.
Then you come to section 30, 30. Read it.
Disputes as to apportionment. When the amount of compensation has been settled under section 11, if any dispute arises, the apportionment of the same or any part thereof, or as to the persons to whom the same or any part thereof is payable, the collector may refer such dispute to the decision of the court.
Okay. So the payment that the collector, if there is a dispute arises, the collector cannot decide. This is a question of fact which has to be decided on the basis of evidence. So the collector would not decide, neither this court can decide, unless we have a evidence box there. We don't have that. So we can't decide. So the money out there will be deposited in terms with section 31(2).
Yes, my lord.
Yes.
The present
So
case, my
under
lord,
such circumstances, all these things are to be done by the district judge.
my lord, the present case, the
Why
issue-
should we look into this?
My lord, in the present case, there is an award and which was cancelled after approval conveyed by the government as well as pronouncement of the award. We are challenging the cancellation
As
of
of
the
now,
award.
the award has been passed.
It was passed and cancelled.
No, it's not cancelled.
It's
That is
cancelled.
what Mr. Malhotra's submission was there on 21/2/2021. That though the award was passed, the award was not cancelled. Supplementary award. That was
No, my
your
lord, it was
submission.
cancelled.
Subsequently, it was cancelled. That is why.
So as of now, there is no award.
No, after its cancellation, a new award was passed.
A fresh award was passed. So if anybody is aggrieved, if an award is being passed, why don't you go and file an application before AR for making a reference to for the district judge?
No, my lord.
It is
Here-
for the district judge to look into it.
What we challenge here is during the time of the writ petition filed by my learned friend, there was no cancellation as such. But subsequently, there was cancellation of the award of 2016. And being aggrieved, we approached this court, this honorable court, and there was an interim order to maintain status quo. And thereafter, my lord, in defiance of the interim order, my lord, there was another award made to some part of the portion of the land, and for which we have filed a contempt petition. And
Understood.
thereafter,
Mr. Counsel,
Yes,
I
my
want to
lord.
make a very clear thing. Has the award been passed or not as of now?
deemed it was cancelled, but as a result of the interim order, which directs to maintain status quo, my lord.
Now the question is whether an award has been passed or not.
The award which is under challenge is under sub judice, my lord.
Huh?
The award which is under sought to be enforced is under sub judice.
Where?
In this case,
How is it sub judice?
this supplementary
You have
award,
not challenged the award.
Cancelled.
we are not challenging the award.
If you
We are
don't
challenging the
challenge-
cancellation of the award.
No, Mr. Counsel, you cannot challenge the award in a writ petition.
We are challenging the cancellation of the award.
Cancellation of an award in a writ petition is completely foreign. An award can be set aside, cannot be nullified. You see, there is a difference out there. An award can be set aside only if there is a violation to section 4, 6, or 11A. These are the three reasons on which an award can be nullified. Otherwise, the compensation or adjudication in the award can be made differently or can be interfered with or modified in terms with section 20 by the district judge or on appeal by the High Court under 54. That's it. Or you want to go under 136 to the Supreme Court? Very well, you are at liberty to go there. So these are the reasons how an award can be interfered with. So how is the award a sub judice before this court?
We are challenging the cancellation of the award, my lord.
Where's the cancellation?
Oh, my lord.
A cancellation of the award has happened and thereafter there is a fresh award passed. That is why you have filed a contempt.
That award 138, in respect of 138 is not finalized.
Yes, madam. Tell me. I don't think the petitioner has a case.
Yes,
If
my
you
lord.
want to make a good case for the petitioner, tell me.
My lord, the supplementary award 1 of 2016 was already cancelled before they have filed the writ petition.
Now do you have an award or not?
Thereafter, my lord, with this court's order, this honorable court has already modified the order, the status quo order. And thereafter, my lord, we have made a draft award number 1 of 2022.
Understood.
In
but
respect
a
of-
draft order is different from the award.
Yes, my lord.
A draft award is being placed before the authority,
Yes, my lord.
the government. The government is going to approve it and then it becomes a final award.
Yes, my lord.
Now, whether any final award has been passed or not.
Not yet, my lord.
Huh? Why? You see, the problem which is otherwise happening is that people are losing the compensation. Some people are not getting the compensation. And on the other hand, their rights are under 300A is also violated. Who is the writ petitioner in 90? You.
I am the writ petitioner, my lord.
Let us see what is your case.
If I may take a lordship to my prayer first.
Prayer,
So
no,
that-
first let me see what is your petition. You are 1 and 2, Longtree District Landowners Association and so president of so. Now what is your case? Impugn minutes of the meeting, impugn and all the notifications issued in pursuant to the impugn minutes, we set aside verification and already made in terms that should not be upheld without conducting another verification if pressed to find the genuineness of the claims and passes. The respondent authority's concern should not be directed to disperse the compensation in terms of the demand. Respondent should not be able to extend the benefit of the directed to extend the benefit of the right of the compensation. No, if the supplementary award is not there, how does your writ petition survive? It has been cancelled. Your entire case is on the supplementary award.
My lord, we are challenging the cancellation, my lord. If I may take a lordship to the cancellation order. Before that, my lord, the first phase of this stretch of road, compensation was paid, the first phase one, during the year 2010. And after conducting verification, one after another, as many as 3 times, along with the SCB, besides the department officials, ultimately they have found that these persons in the award, supplementary award 2016, were genuine, 303 of them. And accordingly,
Mr.
they have.
Counsel, I understand, but the supplementary award is no longer there.
My lord, I'll come to that. The reasons of cancellation were impugned in this case, my lord.
Everything is understood, but when the supplementary award is not there, what remains in your petition? Tell me.
We are claiming for compensation, my lord.
You want compensation.
Yes, my lord.
You want compensation, you will get a compensation if there is an award. If the award is not passed, how can you get a compensation? Tell me.
There was an award, my lord, which was arbitrarily cancelled,
Which one?
2016.
16 supplementary award.
Yes, my lord.
1 of 2016.
Yes, my lord.
That was in your favor.
Yes, my lord.
That was cancelled.
Arbitrarily cancelled.
So have you challenged that?
It is challenged in this writ petition, my lord.
No, respondent should not be directed to disburse the compensation in terms of the supplementary draft award dated. It is a draft award.
My lord, my prayer A.
Minute of the meeting, impugn cancellation order. Let us see 49/2000 here. Where is that? Annexure 25. Pronouncement of the pronouncement of the supplementary award was made.
Yes, my lord.
As per the provisions of 12(2) of so and so, construction of RIA from Iman is announced on this day on 17th Iman in presence of the representatives. Okay. Then minutes of the meeting of the chairmanship of the chief secretary of the Mizoram regarding land.
This page 126 is the impugnment minute.
Where is the award? In pursuance to the minutes of the meeting under the chairmanship of the land acquisition in supplementary draft award of Iman made by the deputy commissioner is hereby cancelled. So you want that draft order.
Yes, my lord.
You have come against the supplementary award being cancelled.
Yes, my lord.
This is it.
Yes, my lord.
Now against that, a fresh award has been passed subsequently.
Subsequently, one award was made. Before that, that award of 2019 was made in respect of some portion of the land on the stretch of road. Bidetasi, my lord. So thereafter, they have prepared another award in the year 2022, which is not yet finalized, even though this court had modified the status quo order. Now, subsequently, after pendency of this petition, the Ministry of Road Transport and Highways, who were not initially made a party, were impleaded, and we are waiting for their response, the affidavit.
Yes, the government, how can you cancel an award which has been filed?
My lord, I have filed my affidavit dated 24th April 2024.
24th?
Yes, my lord. Your Lordship, here we have explained in detail why the reason we have cancelled. There were many bogus claims, my lord.
Now, on 11th of March 2020,
No, my lord, April.
that is the affidavit filed with respondent.
24th April 2024.
In which case?
In WPC 90 of 2019. This is filed by the respondent number 5.
WPC?
90.
There is one affidavit filed by one on 11th of March 2020.
My lord, we have filed several affidavits.
That is the affidavit. Why you have cancelled it?
My lord. In our affidavit, my lord, we have explained that there were many bogus claims and the ACB intervened. And most of the petitioners, they have a criminal case pending against them.
And what have you done with regard to that person concerned, the deputy commissioner who has done, or the deputy secretary or the under secretary who has approved, as well as the principal secretary who has approved? What have you done against them? Have you put them behind the bars?
My lord,
Because you
I'm
cannot.
not aware of the
No,
investigation
you
as
cannot.
of now.
You on 7/7/2017 had categorically announced that we have passed the award. Initially, the award was something around 59 crores. Later on, 59 crores, na?
My lord, there were 303 LSC holders.
No,
according to
initially,
the
it was the supplementary award was 59 crores. Then you said that,
59.
and then you said that no, it should not be 59, it should be 58. And 1 crore 18 lakhs was the total contingency, which has now been made 1 crore 17. That is what the DCLA wrote it. On 7/7/2017, you have categorically published the award. Now, in view of that, it is final. You want to take, show me a provision by which an award can be nullified. Show me. I'm coming back. 5 minutes. Find out how a provision of an award can be nullified. Land Acquisition Act. Yes, madam.
My lord, after the supplementary draft award was made, my lord, we have come to know that there were many bogus claims. And because of that, my lord, there is a criminal case pending against most of the petitioners.
Now, in these cases, the possession of the land has not been taken.
My lord,
Taken.
When were the possession taken?
possession, tak superficial.
Possession taken.
Yes, my lord, I think it's already taken.
Of their lands.
Yes, my lord. My lord, if your lordship can kindly produce the affidavit which I have made on 24th April.
I've seen your affidavit which has been filed on 11.
No, my lord, 24th April.
Huh?
24th April of 2024.
Where? In which case you have filed?
WPC 90. There's another
90.
different aspect in this case also, my lord. The forest.
24
Yes,
April,
my lord.
yes.
In para 2 at C, my lord, 2C, we have discussed the land holdings.
As of now, where is the question of any violation in view of this affidavit? There is no award.
My lord, if your lordship may kindly see the impugned minute of cancellation for cancellation.
No, I have seen this affidavit.
It's not
Signed on
saying, it's not
24th.
saying the grounds they have taken.
No, no, as of now,
Yes,
the
ma'am.
award which was the draft award of 1/2022 has not yet been approved
22.
also by the government.
22.
22 has not yet been approved by the government. What could be seen is there were already 2 awards passed in 2010. Thereafter, there were many persons who have claimed that they were left out. So there was a passing of a supplementary award that is of 1/2016. Now this supplementary award was cancelled for various reasons, which they have stated. Now pursuant thereto, while the matters were pending and in view of the order of 21/2/2021, whereby the order of in status quo which was directed was modified, thereby granting them the liberty to go ahead against the 138 genuine claimants, there was a direction they could go ahead and do it. How will they do it? They will have to pass an award. Now, it is in that premise that the draft award of 1/2022 was passed, made, but it is not yet given any finality. Then, where is the contempt? There is no contempt as of now.
My lord, if I may rephrase, that contempt is in respect of not 2022 award, draft award, but in
That
respect
award
of
has
2019.
not yet been passed. There is no approval of the government till now. There is
That-
a reason why.
This
The reasons
contempt-
have been categorically mentioned that the Ministry of Road Transport and Highways, for who is the requiring authority,
Yes, my lord.
have not issued the clearance. The draft award in respect of an area have been approved by the Land Department of so-and-so. The same has been forwarded to the Executive Engineer. Sanction for compensation is being awaited. So that has been no award. It as of now has been filed. So there is no award at all.
My lord, that contempt petition is in respect of award 2019.
So there is no contempt. There is no 2019 award now.
There is, my lord.
Where is that?
It's in the contempt petition, my lord.
2019.
Where?
Page number 20.
Huh?
My contempt petition, my lord. Contempt case number 1 of 2020.
This is asking for an approval. Where is the award? There is no award.
Page 21, my lord. This draft award was approved and disbursed.
No, this is a somewhat MRNDA given under, this is what they have asked for. But where is it that it has been approved? Has this been approved, madam?
It was already disbursed, my lord.
There is nothing done. All these things have gone for a 6 in view of the thing that now only 138 persons will be entitled.
Yes, and that also, my
Nothing
lord,
remains in your contempt petition. Nothing remains in your contempt petition. Nothing remains also in your writ petition, taking into account that they have done it in terms with. Now, has the possession been taken?
Yes, my lord.
If the possession has been taken, then you have to pay them the damages. That's it. In terms with 48. Nothing more. And then they have to go for a fresh award. If they want to take it, if that is your land out there, they have to take it. If the petitioners have LSCs out there of which their lands are being taken over, then you have to acquire it.
yes, my lord.
Otherwise, you cannot do anything. If it is not being included, they have to acquire it.
It was already verified and concluded that our land was, road was constructed over our lands.
Huh?
Road the construction of road was done over our land. That was already verified and concluded.
Has your land been taken over?
Yes, my lord.
That is the problem when you come up with an association thing, na? Here you see the association, which land has been taken. Let us see your pleadings in that regard. What do you say about the 2019 award, madam?
2019. 19, huh?
Contempt petition.
Cancel. Procedural.
No, nothing remains in your contempt. Contempt is gone. The hook. Let us first dismiss your contempt. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Who appears for whom? You are appearing for whom? Contempt?
My lord, I'm appearing for the DC, respondent number 6. DC, wait,
Ms. So-and-so appears on behalf of the
DC and the engineer-in-chief PWD.
appears on behalf of the respondents. The instant contempt application has been filed alleging willful and deliberate violation to the order dated 19/7/2019 passed by this court in WPC number 90/2019. At this stage, it is pertinent to mention herein that the petitioners herein had filed a writ petition being WPC number 90/2019, seeking a writ in the nature of mandamus that the petitioners should be granted the compensation in terms with the supplementary award number 1/2016, and further challenging the cancellation of the award, supplementary award number 1/2016. It is relevant to take note of that pursuant to the filing of the writ petition, this court, by an order dated 19/7/2019, issued notice and directed that till the next day, the status quo as on 19/9/2019 be maintained by the respondents. The allegations so made in the instant application as regards the violation is on the basis of a purported award dated dated 27/9/2019, passed being draft award number 1/2019, which as per the petitioner was in violation to the order dated 19/7/2019, in as much as there was a specific direction upon the respondents to maintain status quo.
19/7/19.
19/7/19. Full stop. This court have duly perused the various affidavits which have been filed in the incident proceedings, including the affidavit filed on in the incident proceedings, including the affidavits which have been filed in the accompanying writ petition, being WPC number 90/2019. This court have also taken note of that the interim order which was passed on 19/7/2019 have been modified by this court by an order dated 8/12/2021, whereby this court had categorically had permitted the respondents to go ahead in taking appropriate action so that to pay genuine landowners numbering 138 their due compensation. It is pertinent herein to take note of that on 24/4/2024, an affidavit has been filed by an additional affidavit was filed by the Deputy Commissioner cum District Collector, Longklai District, in pursuance to the order dated 6/3/2024, passed in WPC number 90/2019. From a perusal of the said affidavit, it appears that there was no award there was no such award, that the draft award number 1/2019 was not given its logical conclusion. It is only pursuant to the order of modification dated 8/12/2021 that another draft award number 1/2022 have been made. Under such circumstances, the question of violation of the order dated 19/7/2019 as alleged in the instant contempt application does not arise. Accordingly, the contempt proceeding stands dropped. This is goes contempt proceeding. Now let's see the repetition. I closed. Okay, now repetition. Yes, Mr. Malhotra, what is your case? I've understood his case. His case is giving me the supplementary, give me supplementary 1/2016 order. Now, as regards your case, what is your case?
My case has become infructuous because my case has become infructuous
Fantastic.
because I had paid for a payment in accordance with the award 1/2016.
That has been
That
cancelled.
has been cancelled.
No, he's also the same.
But he's challenged the cancellation. He has challenged the cancellation.
Okay, you have not.
No, no.
Depending
Depending on the outcome of his case.
2019. Heard Mr. A.R. Malhotra to learn it counsel appeal.
Depending on the outcome of his case, my case may survive.
His case is also going down the drain. There's no worry with it. His also case is also. But only thing is, if the possession of his land has been taken, you have to acquire it. Without making acquisition, you cannot take his land. That direction I'm going to pass.
138, 138, genuine.
And another thing, my lord, the
Because
acquisition
otherwise it
proceeding-
will be a violation of Article 300A.
In fact, Your Worship, the project is, I think, 99% completed already.
No, therefore the question will arise that if your land has been taken, how do this court look into that? Let them pass the award of 1/2022. Once they pass the award, you can very well move under 64 of the new act and say that you are entitled to compensation also. I think that is the way out by which the district judge can very well decide as to whether you are entitled to compensation. Because this will require evidence.
verification was already there, my lord.
Huh?
Verification was already done so far as the construction of road is concerned.
No, Mr. Counsel, your case is your land has been taken away,
Yes, my lord.
but you have not been paid the
Yes, my
compensation.
lord.
They say that we have only found 138 persons who are actually the genuine claimants for whom we are drawing up a particular compensation package of this award. Now the question arises is if your land is there and you have not been paid a
Yes,
compensation,
my lord.
you are entitled to compensation.
Yes, my lord.
How do you move it? You have to then move the district judge, the file and reference application under 64 and require and say that I am entitled to. The district judge will then decide, look here on this basis that this is the amount of compensation I'm entitled to. Otherwise, how will this court, 226 court, decide as to which are the claims, which are not the claims, which are genuine claims, which are not genuine claims?
Now, as your lordship had mentioned, 138 is not disputed at this stage.
You come within 138?
Yes, my lord, of course, some of them.
So
They will
then
in
very good.
association. And if strict direction may be made, directing the the respondent authorities to finalize the award which was already made in the year 2022.
Huh?
The award which was already made for 138 of them in the year 2022. Let the direction be made, given to finalize the same and make payment within a specific time frame.
Absolutely. No, they have to pay, otherwise it will
Yes,
be a
my lord.
violation of 300A.
And
They cannot under any context. Your
Yes, my
possession
lord.
has been taken, so
And,
under such circumstances they have to pay.
in view of section 24 of the new act of 2013,
And anybody, because here you see, you have come as an association.
yes, my lord.
There are some members who come within 138,
Yes, my lord.
some members who do not. So what will happen is, because the others, they have to file individual applications. Show them. You see, these are like suits. You are to file appropriate application before that authority under 64. Because in view of 18, this repealing of the Land Acquisition Act, the compensation has to be paid as per the new act.
Yes, my lord.
The awards have been passed subsequently after 2014, as has also been stated in the affidavit. So under such circumstances, these persons will be entitled to compensation as per the new act.
Yes, my lord.
Now, for that, you need to file appropriate applications if you want that you are also entitled.
For the remaining,
Anybody's land has
yes,
gone.
my lord.
So then the reference court can direct. If your area is covered under the section 4 notification, was your area covered under the section 4 notification
Yes, my lord.
as well as the section 6 declaration?
Yes, my lord.
We both dispose of both the petitions. We dispose of both the petitions now?
My lord, one more submission, if I may. Will in respect of the award which was made 2022, that has not the award which was subsequently made by the respondents on 2022 in respect of 138 of them. Will that be directed to be finalized or?
Yes, they should pay. Because these people's land has been taken.
Yes, my lord.
300A is violated. If they don't pay, you see, in terms with Article 300A, you can take over somebody's property only by process of a due process. The due process is by payment of compensation. So if you don't pay compensation, if you see that the recent judgment of the, I think Justice Vikram Nath, Kolkata Municipal Corporation, have a look at that, as well as also the another judgment in by Justice Pardiwala, very recent judgment, another one. You see those two judgments, they are bound to pay. If they don't pay, this will be a violation of Article 300A.
If the direction may be made without prejudice to the further claim for the remaining claimants.
Anybody who is outside,
Yes, my lord.
outside the 130A,
And I
if
believe
they
that.
have any claims, they can approach and file appropriate applications seeking that they are entitled to compensation. And then the district judge will decide you are entitled
Yes,
to
my lord.
compensation.
And if direction may be also be made to make assessment in terms of the 2013 Act.
You see, if 138 is getting as per the 2013 Act, why won't you? In the affidavit, they are categorically
Yes, my lord.
mentioning that these
I'm just worried that
138 are
if-
getting as per the right to fair compensation.
If the 2022, which was already made, has been done under the 1894 Act,
Huh?
if the 2022 award which was already made is under the LA Act of 1894,
In fact, what they have done, they have made a blunder out there by going under the provisions of the MOT Act, the DIS Act, because it is being taken by the for highways. It's a highway line, isn't it? Madam, you are national highway.
this is special project.
This land is required for the purpose of highway. That is why MOT is paying the amount. Ministry of Roads and Transport. In
My lord,
fact, they should have taken under the National Highways Act.
Monsieur, my lord, I was directed to obtain instruction by this order dated 30/4/2024, wherein they just stated that relating to the 138 genuine landowner, whether the Union of India should make a procedure of payment or not only, my lord. Then they stated that regarding the 138 genuine landowner, we are waiting the revised cost estimate from the state PWD for
They have
making
already
something.
made the award. The draft award is already there. Where is the question of revised estimate?
My lord,
Isn't
another
that
problem that can crop up is with regard to the forest land. The Supreme Court has held that the degraded June land is a forest land. And I don't know whether the Ministry of Environment.
You have asked for declassification of that.
Yes, ma'am. Whether they'll be willing to pay for the forest land as well as the degraded June land. That will be another problem that can crop up. Because the private land is only for 42.84 hectares. The rest are forest land and degraded June land.
They say that if they make a payment in respect to that amount, as per the National Highways Act, if they make a payment, it will amount to double payment because these people are not entitled to,
Yes,
as regards to, because there cannot be an LSC in respect to forest land.
yes, madam.
Yesterday, as I was going into that particular Mizoram Land Revenue Act, I think 2012 or 1956 or something, categorically mentions that land which is the forest land is outside. So there cannot be an LSC out there.
Yes. And in this case, they all have the land passes. Let's have it on, no. And the reason why we could not disburse yet is because we have not received any clearance from the.
But if you have not got those clearance, how did you at all prepare the award? Means partly today you are going, tomorrow somebody else will come up and say, and then you are going to make another award. These things are never heard of. At the end of the day, the petitioners are suffering.
Moreover, my lord, other similarly situated landowners were already paid back on 2010.
That is okay, they have got it in 2010. Those are some 300 or 400 people, they have got it. That is
We are
another.
similarly situated.
But these are the supplementary awards.
Yes, my lord.
But, madam, you cannot keep on waiting for them. And the payment is to come from Mott,
Yes,
More.
and Mott is not paying.
not paying.
The instruction which they received as submitted by
And
my
Mott
lord.
has constructed road over there. Return the land. You know which area your land is, Mr. Council?
Yes,
You
my
know
lord.
it. Okay, take over that land. We give you the direction, take over the land. If Mott is not paying, they are not bothered to pay, then there is no award being passed where lands have been taken. You get your instruction when the land possession of these lands were taken. We'll have it next week, Monday.
All right.
Get your instruction when these lands of these people who fall within the supplementary award of 1/2016 were taken. On the basis of that, if it is seen that those land, the possession of those lands were taken by the state or the year in the year 2010 or even, and nothing has been done, we are directing them to take over the land or to hand over the possession. List this matter again on
28.
28, on 29/10/2024, on which date both the state respondents as well as the Ministry of Mott, Ministry of this, as well as the Union shall apprise this court as to whether the possession of the lands belonging to the claimants in respect to the supplementary award number 1/2016 were taken by the said authorities, and if so, when.
Obliged.
It will be-
Item number 15.
Yes, what is this?
My lord, this is
Order
an
6
application
Rule
for
17
amendment, my
for
lord.
what?
This is an application for amendment of the appeal petition, my lord. In the appeal petition due to inadvertence, my lord, the words "an ex parte order dated to 11/2016" was missed out in the prayer portion of the memorandum of appeal. If I may take a lordship to the memorandum of appeal. At page number 7, prayer number 1, that is the part where the said words have been missed out, my lord.
Where is that award order? What
Pardon,
are
my
you
lord?
challenging? Which order you are challenging?
I'm challenging the
28/7,
judgment and order
2020.
dated 28/7/2022. my lord.
The 28/7/2022. Now, what do you want to bring in by way of this amendment?
My lord, the factual situation in this matter is that hearing was already conducted in this matter.
Huh?
Hearing was already conducted.
In the prayer version 7, the following may be added: an ex parte order dated 2/11/2016. What is this order?
My lord, this is an ex parte order. Passed
Which one?
on that day,
No, this is a decree.
2/11, my lord.
What are you challenging?
My lord, I'm challenging the judgment and order dated 28/7/2000.
Then why do you want that 16?
My lord, that is the direction that was given to me on the date of the hearing, my lord.
For what?
To add this particular line to the prayer portion. Because, my lord,
No, what is this order? Ex parte order dated 2/11/2016 is which order? Where is that order?
in the, my lord, in the order sheet, in the lowercase record, my lord.
Huh?
In the order sheet of the lowercase record, my lord.
Lower court records.
My lord.
Mr. Counsel, you don't require to challenge this.
Pardon, my lord.
You don't require to insert this.
That is my opinion, my lord. But
Not
I was
necessary.
directed to
No, because
make this
you see,
amendment, to apply for
Why
this amendment.
the reason is very specific. If you have see the CPC
My lord.
103
My lord.
and 105, any order being passed, you can be very well you challenge it. At least see 105 of the CPC. That will be a part of it. You don't need to challenge it.
My lord, the opinion on the last
Other orders. Save as otherwise expressly provided, no appeal shall lie from any order made by the court in exercise of its original or appellate jurisdiction, but where a decree is appealed from, any error, defect, or irregularity in any order affecting the decision of the case may be set forth as a ground of objection in the memorandum of appeal.
my lord.
That's it.
My lord.
You don't require.
My lord.
And secondly,
My
the
lord.
memorandum of appeal cannot contain a prayer. Isn't it? See? Appendix 1. Yes, you cannot have it. The appendix G of the CPC.
Okay.
What it should contain? The above mentioned appeal to the court of the for a decree in the suit so and set the following grounds of objection to the decree appeal from. Only the grounds of objection. The
That's
learned
a-
counsel appearing on behalf of the Mr. So-and-so, the learned counsel appearing on behalf of the appellant, as well as Mr. So-and-so appearing on behalf of the
Respondent number 1.
respondent number
Respondent number 1.
1. And Ms. So-and-so appears on behalf of respondent number 2, 3, 4, and 5. This is an application filed under Order 6 Rule 17 of the Code of Civil Procedure for amendment of the memo of appeal, thereby to insert to make certain amendment to the relief sought for in the memo of appeal. The learned counsel appearing on behalf of this court, upon taking into account the provisions of Order 41 Rule 1, read with Appendix G of the Code of Civil Procedure and Section 105 of the said code, is of the opinion that such amendment is not required as per the provisions of law. The order dated 2/11/2016, by which the suit proceedings had proceeded ex parte against the appellant, can very well be put to challenge, can very well be a part of is within the scope of the appeal in view of Section 105 of the Code of Civil Procedure. Accordingly, the I stands closed. In the memo of appeal, you can only amend your grounds of objection.
My lord.
That's categorically provided under Order 41.
My lord, that was the opinion, but at the last moment, the order was dictated that I was to make the amendment. That is fair. Deeply obliged, my lord.
For hearing item number 19.
Yes, what is this?
My lord, this is a criminal appeal, my lord, wherein the accused appellant has been convicted under two sections, my lord, 489A, B and C, my lord.
What is these sections?
These are for fake currency in Indian notes, my lord. 489B, 489C, my lord. And he has been sentenced to undergo under 489 for 3 years, my lord. For 6 years, and 489C for 3 years.
Fake currency?
Yes, my lord. Now, whether the main thing that will come for your lordship kind consideration is that whether I was actually in physical possession, whether it was recovered from me at all or not. Because the story of the prosecution is that two persons was in a motorcycle, and the bag containing the fake currency note was found in the handle of dangling in the handle of the motorcycle. So now they have made a case that I was in physical possession, conscious possession. There the whole judgment revolves on that point only, that I was in a conscious and physical position, which is not correct as per the evidence coming on record. And there are many latches and loops, my lord, I would like to show your lordship. Because 7 witnesses, though numbered, has been examined, but practically 6. That is a surprise element I could see, my lord. They go by the serial list PWs. There's a paper book, madam.
Yes.
So let us first start with the first information report, madam, how the case originated. There was an information to the Varangati police, madam, that some fake currency notes are being. That is at page 1, madam, the complaint, madam.
The paper book?
Yes, madam.
Page 46.
My lord, we have got the marking of 1, my lord.
Huh?
The first 3 pages, madam. After the index.
It says to the officer in charge, Bharang.
Yes.
I beg to state
This is
that
marked as
only one
exhibit
special
P1.
narcotic PS has
Operation at Varangati has seized the huge
seized
quantity of suspected FICN is fake Indian currency note of 2,434 pieces, M denomination 500, 1465 pieces. A total value of 16,500,000 from the possession of Azmal Hussain, which is Mazhar Bhuiya, who is the accused appellant, son of such, district Hailakandi, Assam, at Counter Vente, Varangati near Pioneer Camp at around 2 p.m. I therefore beg to state a case may kindly be raised against him and to for possession of suspected fake currency note. Now, this Zoromatha silo was examined as PW. Marked as PW1, my lord.
Okay.
So your lordship will take note of the pieces, my lord, because there is a huge discrepancy, my lord, what is said to be found and recovered and what is.
PW1.
Yes, my lord. Here, if I will calculate it, my lord,
Position
14,
of the
1, yes,
witness
1465. We have prepared the motion.
Okay.
One 465 into 500, 434 into 2000 makes it total into 1899. But when the FSL was done, it changed into 1819. So 80 pieces were less also, madam. So the recovery itself is doubtful, madam.
Yes.
So, my lord, accordingly.
So who seized it?
Seized it by PW1, my lord, who is the seizing authority. He kept it in his own possession.
So, but in number 5
yes,
of his cross-examination, he says that it is a fact that I have made a deposition as a complainant. It is also a fact that the case IO has also recorded my statement only as a complainant, but not as a seizing officer. And I have also
though he was the
testified
seizure,
the accused only as a complainant.
though
but
he
not
was the
as a
person who affected the seizure.
Huh?
Though he was the person who affected the seizure.
Yes.
Because Varangati PS received an information that there is something going on to happen. So accordingly came in a raiding party and they recovered the money. At that time, it was in a motorcycle driven by 2 persons. One person, I don't know how it vanished, my lord. And
But where do you say that it is on a motorcycle?
my lord, that is your lordship will find in the evidence of PW7 IO at page 11.
IO? But he does not say anything.
He does not say because he is the seizing authority.
Neither
He is
it
the-
has been
yes,
stated out there in the FIR.
yes.
Neither it is nor it is stated
Mentioned.
out there in he that he only says that he has possessed from the possession of so and so.
Yes.
I recovered 60.
See, my lord, if your lordship will see this huge note currency, whether it was carried in the bag or in the jacket or in the body or in the bag or kept somewhere concealed, my lord. So IO's evidence is made clear at page 11. If your lordship will kindly turn to page 11, fourth para, my lord. In the course of my investigation, I have examined the complainant, witness, and accused. I have also arrested the accused Azmal Hussain Barbuya, and arrest intimation was given to his relative. The next slide. The above mentioned fact Indian currency note.
You are saying about page?
I'm
number?
reading from page 11, madam. evidence of IO
Seven,
PW
seven.
7. Para 4th, my lord.
His name is
His name is this one, my lord, Ajmal
Lalam
Hussain
Puria.
Mohammad Bhaiya. And here witness's name is Lalum Pia. Sorry for not being corrected. Lalum Pia. He is the IO of this case, my lord. The above mentioned FICN was seized by the complainant, that is PW1, which was kept inside a bag, kept on the handle of the accused motorcycle. My lord, no bag, no packeting and sampling.
Now, in his chief, he does not say anything.
He says in the chief only, my lord. This part is the chief part.
No, that
Motorcycle.
it is in the from the motorcycle. Yes.
Yes. That is chief, my lord.
The
Cross
above
starts
mentioned
next page.
FICN were seized by the complainant, which were kept inside a bag kept on the handle of the accused
And
motorcycle.
2 persons were coming. 2 persons came from Silchar to Aizawl, my lord. In that place, they were apprehended. But where did the second person vanish, my lord? There is no explanation to that. One independent witness was there, my lord. Probably he may be, but he was also not examined, my lord. He was PW4. So though it is listed as there were 7 witnesses, but PW4 serial has not been examined, my lord.
How did you know about this thing that there were 2 riders?
It has come up during investigation, my lord.
Investigation. Means there has been something recorded somewhere, 161 or something.
Maybe, my lord, but we are given this paper book, my lord. Going from there, my lord, we don't find it how he has come to know, my lord. But on record, it is established that the complainant, actually the complainant should have first brought the GD entry on the basis of which information they came out, or that GD entry when they deposited the money in the Malkhana, where it was registered as Malkhana. So there must be a GD entry, my lord, and I think the GD entry is 88. But that GD entry has not been brought. Otherwise, it would have.
Is not there in the records?
Yes.
Have you seen the records?
Yeah, I have checked it, my lord.
It is not there.
It's not there because they have registry has given the list of documents.
But are the 161 statements there?
At that I haven't checked it, ma'am.
We'll have a look at
Because
it.
these
We'll
are
take it.
the case diary will be
Case
there.
diary, have a look at it. We'll take it up at 2.
Yeah. Ma'am,
Show me the record. So, Mr. Kamal, what is your case?
My lord.
What is your case now?
The case is that, my lord, that nothing was recovered from my possession, my lord, and they have miserably failed to prove that I was ever in possession of that fake currency note. As per my learned friends going through the records, my lord, it's recorded in the vernacular, my lord, in the local language. She has just translated and said that he was brought by someone, my lord, Ataur Rahman, and he was driving it since he didn't know to drive the motorcycle. And
Driving a?
motorcycle, my lord, motorbike.
Along with?
Along with one person, Ataur Rahman or something like that.
Yes,
my
his
lord.
uncle.
Ataur Rahman, my lord. And
My
that
lord,
way-
all the 161 are in vernacular language, so
Huh?
it's in vernacular language.
Beg your pardon?
Vernacular.
Vernacular language, my lord.
This is in vernacular?
Yes. And it's not
161.
included in the paper book.
There is one other person whose witness is taken, Ataur Rahman 58.
Yes. He brought him, my lord, from Lailapur to Aizawl, my lord. And he was not aware, my lord, that these things will happen.
Now, how does Ataur Rahman come into the picture?
Because both persons were in the motorcycle.
But there is nothing mentioned anywhere
Yes.
by the Caesar witness, neither by the, only by the investigating officer, he says something on that.
Yes.
But investigating officer does not even say, neither any cross-examination is being put as regards Ataur Rahman.
That is my respectful submission before your lordship, my lord. Then
So without understanding what he has stated under 164, this one,
161, my lord.
this is 161
No,
by
160.
Ataur Rahman.
No, Ataur Rahman is also there because he fled away, my lord. He vanished. The-
Now, how did the statement being taken? Statement of witness recorded
lord.
in connection with Ataur Rahman.
Yes.
How?
My lord, that on the spot probably it was taken. I am not aware, my lord.
It can't be so because this is
No,
by
no, why I
the
say so, my lord?
investigating officer.
He was listed witness as witness number 4, but he was never examined in the court.
But his evidence was not taken into account.
Yes, that is why, my lord. My lord, the main person has been allowed to go, my lord, and somebody innocent has been held up in this case, my lord. Because if your lordship will see the Caesar, my lord,
But there is not even a suggestion in your cross.
yes, that is there, my lord, but because,
Then
no, one
how do you bring
PW
in
7, my
Ataur
lord, it
Rahman
will
to
come,
the
my
scene?
lord. Because everybody is saying there is a huge discrepancy regarding the recovery also and the seized currency note, my lord.
Huh?
Seized currency notes, my lord.
What
There
is
is a
the
huge
discrepancy?
discrepancy.
Initially, yes. In the FIR, they have written it as 434. But later on, it was made corrected out there in the charge sheet also. But in the FSL,
Yes,
it was
that is
found
what,
incorrected.
So,
And on re-examination, they said it to be 431.
yes. So my respectful submission, my lord, what was seized actually has not been brought into the trial, my lord. So there is a huge discrepancy, my lord. Because the original fake currency notes were seized to be more than 1899, my lord, pieces, my lord, when it was seized, my lord. And
No,
the
no,
big,
no. Originally, when it was seized, it was said to be 16 lakh 5,000.
yes,
Subsequently, when it was sent out there to the FSL, it was said to be 431 fake notes instead of 434.
yes, correct.
So there was some less, but this was
Great lapse.
clarified in the re-examination by the the prosecution
FSL
witness number 7.
and the I.
He
Well,
has
I'd like-
clarified that. But the question as regard his possession is there.
No, my lord, it's not from my position. I'll try to impress upon your lordship. If your lordship will kindly bear with me for a moment. In the cross part at page 12, my lord.
Yes.
That is made more clear, my lord. From the down, my lord, it is the fourth para, my lord. 1, 2, 3, third line, my lord, third para.
It's a fact that there were two riders
In the bike.
in the bike at the time of recovery of the seized. It's a fact that essay. What is essay?
Seized articles.
Seized articles were
was
seized from the steering handle of the bike. However, I did not see the recovery. So obviously he was not there.
No. Correct.
So it was seized from the bike, but this person, the person who seized it, as well as the seizure witnesses categorically say they identify you as the person for whom
That
it
is what
been
I'm
seized.
saying, my lord, that I have been wrongly implicated in the case.
How?
Yes, that is what, my lord. It was never recovered from my possession. The bag was dangling, hanging on the handle.
No, the seizure witness categorically said that.
They have
As
wrongly
well
said,
as
my lord.
the seizing officer also said that it was recovered from you.
No, that is what, my lord, this has been wrongly stated, my lord, in view of the investigation surfacing the materials. They have not said from where it was seized. Seizure list, if your lordship will look into, my lord, it will be crystal clear, my lord, that there was nothing mentioned from which part of my body and how it was seized. That is the important thing, my lord. If I was hanging the bag in my shoulder, my lord, then definitely it will be. Because it was a huge currency note.
But if it is, there are many judgments also to the effect that if it is a private vehicle belonging to the person concerned, then automatically the seizure, the possession is in the case of NDPS.
If it is concealed, so my responsible submission before your lordship is that there were two persons. Nobody has said that he fled away, so we could not catch him. Nothing. Prosecution is completely in silent mode, my lord. Only thing is that, my lord, just because I stayed and my statement was recorded to that effect, and I have given my statement that I was brought in by the pillion rider, and I came to visit my uncle. That is what she has translated and stated to me before going to lunch. My lord, that is on record, that has not been brought. So, my lord, in order to find a person having anything, it must be in somewhere, my lord. So, if your lordship will see, only in the seizure list it is written, my lord, that from the possession. That I will show it, your lordship. The seizure list starts at 56.
Yes.
So 56 is the property search and seizure list, my lord. And this, if your lordship will see at the first, my lord, Kola Sahib PS, Kola Sahib District, PS Varangati, year 2020, FIR number GD number K blank, dated 6/7/2017. So this is, things were moving, and then the main branch has been written.
No, here number 5 it is said, it is seized from you.
Yes, that is what they are saying. That is not correctly
Is
saying.
it required
in
that
respect
it
of
has to be
other
seized from
circumstances, my
where?
lord.
It has to be mentioned.
Yes, my lord. That has to be mentioned, my lord.
Where?
But
Show
in the
me,
seizure
that
list.
law that it has to be mentioned from which part of the body or
yes,
where it is.
absolutely, my lord. From the vehicle, inside the dicky, inside the steering wheel, sometimes spare, all these things are to be denoted, my lord. They have made out a case, my lord, but whether in the trial they have been able to prove that aspect. The bag which was seized, my lord, was never produced, my lord, before the court, my lord. Even the fake currency notes were also not produced, my lord. Owner of the motorcycle, my lord, where did the motorcycle go then, man?
This is in the witness which was taken by this police station, this person
All the-
concerned, the seizure witness, seizure officer, that is also in vernacular.
No, my lord, the evidence it is given.
But how does he come to know? You read this?
My lord, page.
Yes, madam, kindly read this page 6. Very difficult. Unless this is here, because otherwise, how do you connect? Ataur Rahman. Hey,
The brother.
Mr. Counsel. Hey. Ask her to read it, this one. This portion, madam,
Yes.
how, I don't understand, how does the PW7 know that there was 2 riders?
Yes, it's
Because
from.
nowhere the seizure witness said, nor the seizing officer said that there were 2 riders.
Yes.
Unless it is being stated out there in that document which I am saying.
Yes.
And how is Ataur Rahman coming to the scene?
Yes. I'll translate it slowly, my lord. My names and particulars are as above, that on dated 6/7/2017 at around 6 a.m. From a reliable source, I have received an information from a reliable source that some person are trying to sell a fake currency note in and around Vairengte. And in pursuance of that, me along with my staff went to Vairengte at around 7 a.m. And we fly by special narcotic police vehicle. Next paragraph. Then after some time, we reached Vairengte at around 1 p.m. and we scattered ourselves and searched for the person whom our source have informed us. After some time, the person suspected was found near Kontharveng, Vairengte Pioneer Camp. And we saw him carrying a red bag, and on seeing him, we apprehend him. And we have informed him that we suspect him of trying to sell a fake currency notes. And we checked the bag that he was carrying. And inside the bag, we have found a denomination of rupees 2,500 notes. We asked his name, and his name was Ajmal Hussain, son of Ataur Rahman of Hailakandi. Son of, yes.
Okay.
And next paragraph. My staff and I have counted in front of witness the money, and the total amount is 16,500,000 rupees. And we seized the articles in the presence of a Caesar witness. After taking the statement of the Caesar witness, we made a record to that effect. There was no civilian witness. Hence, I used my colleague as a Caesar witness. After counting, I arrest Ajmal Hussain, son of Ataur Rahman of Hailakandi, and we proceeded towards Vairengte police station along with the seized articles. And accordingly, FIR was submitted. My lord,
He does not say anything about motorcycle.
Yes, he does not say.
Who says about motorcycle?
My
How
lord,
does the investigating officer?
this is the statement of the accused, my lord, in page number 8.
Accused has no business out there. These accused before the police is.
Yes, correct. But then this is how it came into picture, the motorcycle. So that's it.
Accused.
Yes, from the statement of accused.
There's no business out there. But otherwise, there's nothing,
Nothing.
Motorcycle scene is there.
Nothing is there.
The IO himself saying that during
IO says on what basis?
IO is the person who carries the investigation
Because
as well.
IO is not the person who had seized it.
Yes.
He was not the person who had made the recovery. He was only brought in, the person concerned upon being arrested was brought in.
Yes.
there is no mention anywhere by any of the officials except the IO about a motorcycle. The motorcycle must have come from somewhere. And how does that motorcycle have, because none of the witnesses on the 161 or those people have stated anything about a motorcycle. Because this IO have also not examined the seizure witnesses. He said that he has not examined the seizure witnesses. So he doesn't know from there. How does the motorcycle scene come into this picture?
That is, he is the best person to say, because during investigation what surfaced, my lord, he has stated this.
And where are the two riders coming? There is no mention at all.
There's no mention except from the
Anywhere
exam.
two riders. How does the IO say that?
Because, my lord, there are three witnesses. There are four witnesses, my lord.
There are 7 witnesses.
Because these four witnesses are for Varangati PS, my lord. They were the interested person who wanted to nab the accused, my lord. So, my lord, they did what? That they arrested him at 2 o'clock. Then 4 o'clock, they have shown me as arrested in this case. And at that time, they have stated nothing. Because if they state the truth, my lord, then everything will have fallen flat. So they stick to the theory that it was recovered from his possession. But how can so much currency notes be there? So according to the IO, it was inside a bag. And that bag was hanging on the steering of the motorcycle. Now, if that is so, my lord, how this currency notes, which I am showing it in exhibit P4, my lord, page 58, my lord, there is no mention about the bag. So how much notes were who carried from whom and from where it was seized, my lord? That your lordship will kindly take into consideration, my lord. It is the IO's version, my lord, because he investigated and submitted the charge sheet, my lord. And these notes were seized by PW1. And from him, the IO has never re-seized it, my lord, in connection with this case also.
Huh?
IO has never re-seized it. PW1 on his own, he has done, and he is the informant of the case. Now that money, IO took it. How, my lord? There is missing link, there is a gap. There is no re-seizure of that fake currency notes from the possession of PW1.
There is a requirement of a reseizure?
Yes, absolutely, my lord.
Where?
It is always to be re-seized, my lord.
How do you say so?
Yes, my lord. I'll show, my lord, that he kept it in
No,
his
no, no.
possession, my lord.
What is the law on that? That there has to be a reseizure by another person?
No, my lord, he has to take it now. First,
How, what? Because
My-
this is given. It is seen in this MR something. It is been given out. there.
MR number is there. That is what
It is
I'm saying.
already
my
there.
lord. So he has to take into possession, my lord.
He has
Because he is
taken
not
it.
the IO of the case.
He has taken it here. Kindly see the details of the exhibit 137. Seized by the SI so and so, sealed, packed, and marked as exhibit A.
Your lordship will now kindly see. I'll read the evidence, my lord. If your lordship will bear with me, I'll read first, my lord.
I read the evidence.
Oh, yes, my lord. Now
Tell
I'm
me.
showing my part, my lord. If your lordship kindly bears it at page 4, my lord.
Yes.
Let us come, my lord. Page 4, PW1 to get this one. Page 4, PW1, my lord. He says in his chief from the possession of Azmal Hussain, that is the accused, my lord. Then he sees the fake currency note. Now, if your lordship will see at cross-examination number 3, it is also a fact that we had arrested the main suspect, Azmal Hussain. Then where does this Azmal Hussain come from, my lord?
Huh?
Para
Azmal
three, my lord.
Hussain. Azmal Hussain is the person you are.
Yes. I am Azmal Hussain Mazhar Bhuiya, my lord.
That is where everywhere
Yes.
they have mentioned Azmal Hussain only.
Yes,
Your
main
first two
suspect,
names have
Azmal
been
Hussain
put.
Bhuiya. Now I am reading.
You did not, you may not have disclosed Mazhar Bhuiya at that point.
Take a moment. Let us come to para 4, my lord. It is also a fact as reported by CGM Kolasai by SI Lalrimua. He is the part IO, that is PW6, mentioning that the main suspect accused after Hussain was not known to me and I have no knowledge about the suspect main accused as reported by London Parent. So this after Hussain is another person, my lord. This is PW6 version as per PW1.
Where is the actual, see the records out there as regards PW1?
Evidence. So these are photocopy, I think.
These are
Photocopies, man.
These are actually typed, maybe some mistake,
I will
because
check-
earlier
we'll
they
check
have
it,
made
madam.
Ajmal
But
Hussain.
it looks like the judge signature appears in the next page. Judge's.
You show me that there is a requirement that the investigating officer also has to reseize it. There is a requirement of 2 seizures.
I'll try.
No, there is not requirement.
My lord, it's exactly the same.
My lord, then next page, my lord. It is a fact that I had made a deposition as a complaint. It is also a fact that the case IO has recorded my statement only as a complaint but not as a seizing officer.
I have also testified the
And I also testified the accused only as a complaint but not as a seizing officer. So
I have
he
also testified the accused. What is this? What is the meaning?
testified.
The accused?
I had also testified the accused of the to reconcile it.
So these are all typographical
And
errors.
also testified that as a complainant but not as a seizing officer he has deposed.
It is also a fact that at the time of seizure, the accused had simply possessed the seized article.
Because it was not used, my lord, that is. Because to circulate it is
But
one
Mr.
aspect.
Kamar, what is the finding as regard, there are 2 requirements,
Yes.
twin requirements. One is possession, and that he had also the mens rea that these are counterfeit documents. Where is that finding?
My lord, yeah, I have gone through the judgment, my lord, because judgment revolves only on one count, that it was found from my possession. These witnesses has corroborated each other, that's why.
Because mere possession cannot be.
Well, exactly. That
There
is why.
is the requirement of the twin.
Yes, my lord. That's why that para 6 says it is also a fact that at the time of seizure, the accuser simply possessed the seized article.
No, therefore, where is that? Because it is the burden upon the prosecution
To show, my
to
lord,
prove
that it was
he
in
had the
circulation.
mens rea
To circulate it.
that did not only circulate, that this is the counterfeit document. He had also the knowledge. There are 2 aspects of 439 IPC.
Old.
439 requires 2. One is possession,
Yes.
and the second, there is a mens rea to the effect that he knew that this is the counterfeit. Where is that evidence?
Yes, that is not coming
Because
forth.
that has to be proved.
Yes.
Let us see 439, 489 or whatever.
489 B and C, my lord.
Without that finding, can there be a
That finding is missing, my lord.
that is see, whoever has in his possession any false or counterfeit note, knowing or having reason to believe the same to be false or counterfeit,
He must have done that.
and intending to use the same as genuine, or that it must be used as genuine, shall be punished with years. So these are the twin requirements. Where is that finding out here in the trial?
No, there is no such finding, my lord.
So
with
I
all
think
respect.
that should
I'll
have
take your
been
lordship
your-
to the judgment, my lord.
That
Judgment
should
page.
be your argument better on, instead of sticking
Yes,
in
yes,
the
absolutely.
position.
Judgment page starts from 40, my lord.
Because the judgment, kindly see, there are 3 points for determination. The first is whether the police officer had suspected to be efficient from the possession. Okay, that is one. Whether the seized currency were fake, whether there is liable to be convicted. Now, kindly see number 3, how the trial court looks into
Yes,
it.
my lord. I have,
Kindly see per contra here,
number 3 will be.
the
at
third
two.
point, paragraph
Yes.
10.
10.
Has proved illegal possession of the seizure from the possession and there is no hindrance of the court to proceed with the further. Pertinent to me, ever since the was arrested and immense recovery of the ARA, he came unconscious possession of the Iman. But the fact that he knew
That is
that
not
this
there.
is a counterfeit
Yes.
is not there. And without that being there, how can that be a case of conviction? Isn't it?
That is the one of the crucial factor, Your Lordship. I apologize for that. But then, correct. Because 3 parts has been dealt with it, para 10 categorically deals with that point, which is completely missing. my
And I don't think that if prosecution have anywhere adduced the evidence that this person knew that,
That
this
they-
is a counterfeit.
lord. That is the.
Where is the judgment for that? You have
I have
come
brought
all
one,
the
my
way
lord.
for
I have brought one. Kerala Nigel. Well, I have prepared some notes also, if Your Lordship wants.
Huh?
I have prepared.
I need only one judgment for that. There's a judgment, I think 86. The
This
Kerala
is
judgment
Madan
was-
Lal Sharma, then 3-4 I have brought it by the, with judgment to Diana.
86, 1986, there is one judgment.
For he can be another.
On 489C. B is, what is 489B?
B is that you have to be aware, my lord.
Using. So
yeah.
he is not using. So
No.
B does not come into the picture.
Absolutely.
Using a genuine force or
There was
counterfeit
no
where
using.
or yeah. So he was not using. So B cannot come in. C is this.
That is just highlighting Your Lordship view, my lord. Now, if we go to the market and give it for buying certain things, my lord, then B is attracted, my lord. Knowing or having reasons to believe the same to be false or counterfeit, my lord. Supreme Court, we could not find it directly. maybe.
No, none of these judgments are relevant.
I think Madan Lal covers the case, my lord. See, Your Lordship has, whatever Your Lordship has expressed in Madan Lal Sharma's case, the mere possession of it by him does not shift the burden to the accused to prove his innocent possession of the forced note. That is
There
what.
is a requirement specifically for them to prove that mens rea,
Yes, ma'am.
that he knew that he is going to use it, that this is a counterfeit. That proof has to be there.
And
Without that, it cannot.
it was also not produced in the court, my lord.
Huh?
The counterfeit notes were also
No,
not.
it was produced. Exhibit A
That
and A.
exhibit, only
They
the
are
Caesar
produced.
list.
They are material exhibit A and B.
The Caesar list. probably.
Now, if you see that page which I said,
Uh-huh.
they produced
The-
that.
the
But the
note-
fact that unless you prove that, how do you prove it? Isn't it?
That's,
This is 2019-16 SSC. This is the judgment.
19, my lord.
Yes. Deepak Bhai Jagdish Chandra Patel versus State of Gujarat. Ingredients of the offense, paragraph 9 and 10, has not been established. In section 4, he sought support from the judgment of the Lahore High Court and so and so, so and 10. Finally, also he drew the attention of Iman wherein it has been so and so.
That's the latest problem.
Internet is down.
Here in this case, it was probably fake reals, my lord. Lahore.
Here, 313.
My lord, 313, there is only three questions, my lord. That's highly defective, my lord. Your lordship will find it at page 3, my lord.
So there is no question on that also.
Nothing, no.
No, not
This is
only on the question of that knowing.
knowing. Well, nothing has been put, my lord.
We dictate the judgment. But Mr. Jet Kamar. Yes, madam, anything?
So, my lord, position is clear.
You need the other one, no?
Yes. Position is clear. I can show that, but then,
No, you had the possession.
yes.
There's no quarrel. And that is why Mr. Kamar was also arguing on the possession only.
Yes.
But the question of possession is not the sole criteria. There has to be also, because tomorrow
Mention.
you may be in your
Yes.
wallet also, you may be having many.
But
But
even
the
though
question
they
is,
have,
you have to also know
yes,
that this is the counterfeit.
even though they have missed out before the learned trial court, but then from reading the statement of the complainant from a reliable source, they know that a person is trying to sell the fake currency Indian notes.
No, but that is the evidence out here. Kindly see.
Yes, but then
Uh,
in
with
the
a
evidence they
PW1.
missed that out. Yeah.
Of PW1, he says, it is also a fact that as far as by knowledge of the accused has not utilized the said seized articles.
Yes.
It has also a fact that at the time of seizure, the accused has simply possessed the seized articles. So with these two statements
Yes.
in the cross, how do you show the second element?
I know, my lord.
There the problem arises.
Yes.
Okay? Let me dictate. Heard Mr. Jet Kamar, the learned senior counsel assisted by so-and-so appearing on behalf of the appellant and Miss so-and-so, the learned PP. PP, additional PP.
Additional PP, my lord. Mary L. Kyangte.
Mizora. This is an appeal filed under section 374(2) of the Code of Criminal Procedure 1973, for short the code, challenging the judgment and order dated 7/3/2024 passed by the Learned Fast Track Court, Kolasip, Mizoram, in SC bracket K number 35/2019, arising out of Rengete PS case number 38/2017, registered purportedly registered under section 489B/489C of the Indian Penal Code. Full stop. Whereby the learned trial court, for short the trial court, whereby the learned trial court had convicted the appellant under section 489B to suffer simple imprisonment for a period of 6 years and to pay a fine of rupees 50,000 in default of payment of fine, to undergo further simple imprisonment for a period of 3 months, and also sentenced under section 489C of the Indian Penal Code to suffer simple imprisonment for a period of 3 years and to pay a fine of rupees 50,000 in default, 50,000, in default, to suffer simple imprisonment for a period of 3 months. And both the sentences were to run concurrently. For deciding the appeal, it is relevant to take note of the brief facts which led to the filing of the instant appeal. The case of the prosecution is that on 6/7/2017 at around 2:30 p.m., one Mr. Joramsango Sailu, SI of Police, Special Narcotics Police Station Aizawl, submitted a first information report to the officer in charge of Verengete police station to the effect that on the same day at around 2 p.m., a police team under his command recovered / seized huge number of currency notes suspected to be fake Indian currency notes, bracket FICN, from the possession of the appellant at Kaungatar Varengate, KAWNGTHAR, Varengate, VAIRENGTE. Pusto. As per the FIR, the suspected FICN were 434 notes of 2000 rupees denomination and 1,465 notes of 500 denomination, totaling to rupees 16 lakh 500. The seized FICN. The said FICN were seized, and on the basis thereof, a VRT PS case number 38/2017, dated 6/7/2017, was registered under section 489B/489C of the Indian Penal Code. The appellant was arrested. The investigating officer thereupon made investigation and submitted his charge sheet and they carried out the investigation and also sent the seized articles under proper escort to the FSL, Aizawl, for scientific examination. The FSL examination report so submitted, the FSL, Aizawl, submitted a report stating inter alia that the 500 notes which were marked as Q1389 to Q1818 and the suspected rupees 2000 denomination marked as Q1 to Q1387 were found to be counterfeit, except the denominations marked as Q1819 and Q1388. On the basis of the said report and the investigation being carried out, a charge sheet was submitted under section 489B/489C of the Indian Penal Code. Pursuant thereto, the Chief Judicial Magistrate Kolasi sent the records on committal under section 209 of the code to the fast track court, Kolasi, as the case was exclusively triable by the court of the judge FTC, Kolasi, court of the session judge, Kolasi. Full stop. During the trial, the prosecution adduced the evidence of 7 witnesses.
No, marked as 7, but practically.
And examine 6 witnesses. While the appellant did not examine any defense witness. First, the trial court, on the basis of the evidence, as well as upon hearing the counsels, framed 3 points for determination, page 18 of Pavana, which are enumerated herein under 1 to 3. First, the trial court, by the impugned judgment and order, held that the seized FICL denominations were taken from the were seized from the possession of the appellant as well as also opined that the seized FICN notes were seized currency notes were fake Indian currency notes. On the basis thereof, the learned trial court also came to an also opined that the appellant had committed the offense under section 489B and 489C of the Indian Penal Code, and accordingly passed the sentence as already mentioned herein supra. A date of the judgment question है नहीं करना. উপরে লিখি দিলে এইটো হ'ব এইটো তিনটা পয়েন্টস অফ ডিটারমিনেশন হয় তার পিছত লিখিব the learned trial court decide pass the judgment and order dated so and so 23/2024 whereby এইটা কই দিলো no. It is under such circumstances that the instant appeal have been preferred. You are in bail?
But no.
Huh? You're inside?
Inside.
Ajay might go. Kali utto blaju. Mr. Jet Kumar, the learned senior counsel, appearing on behalf of the petitioner, submitted, appellant submitted, that the impugned judgment and order dated so and so is liable to be interfered with, taking into account that the prosecution has failed to prove the possession of the appellant over the in respect to the FICN in question beyond reasonable doubt. He further submitted that from a perusal of the evidence of PW7 and more particularly his cross-examination, it would appear that there were 2 riders in respect to the motorcycle, and only the appellant have been arrested without specifying as to on what basis, without proving that the FICN were seized in the manner provided in the law from the possession of the appellant. He submitted that from the perusal of the evidence, it would be seen that the FICN were inside, was packed inside a bag. However, the bag was not exhibited. Was neither exhibited, nor was neither seized nor exhibited, as would be apparent from the Caesar memo. The learned counsel further submitted that not only the question of possession was not proved for attracting the offense under 439(89)(b) as well as 439(89)(c), but there was also no proof. But there was and 439(b) and (c). But there was also, but the prosecution have further failed to adduce any evidence to show that the appellant had the mens rea the appellant had knowledge or had reasons to believe that the currency notes were forged or counterfeit, and that the appellant intended to use the same as genuine, or that it may be used as genuine. The learned senior counsel therefore submitted that in absence of such a proof being substantiated, the offense under section 489(b) and 489(c) of the Indian Penal Code cannot be substantiated, and accordingly the impugned judgment and order is liable to be interfered with. The learned senior counsel further submitted that a perusal of the 313 statement, the perusal of the statement of the accused recorded under section 313 of the code also would show that there was no specific question also put in respect to as to whether the appellant had knowledge that these notes, that the seized notes, currency notes, were counterfeit. Or had reason to believe that the same to be forged or counterfeit. And that the appellant intended to use the same as genuine, or that it may be used as genuine. In absence of that, the learned senior counsel submitted that the prosecution, the proceedings stands vitiated. The trial proceedings stands vitiated. The learned senior counsel further drew the attention of this court to the evidence of the PW1 and submitted that the seizing officer had categorically stated that the accused, that the appellant had simply possessed the seized article. and the appellant had not utilized the said seized articles. And under such circumstances, the question of implicating the accused, the appellant, under section 489B or did not arise at all. And this aspect of the matter, the learned trial court completely committed an error. Anything more? No. In that regard, the learned senior counsel have placed the reliance upon the judgment of the Supreme Court in the case of Umar Shankar versus State of Chhattisgarh, reported in 2001, 9 SEC 642. Per contra, the learned so-and-so appearing, the learned so-and-so, the additional public prosecutor of the state of Mizoram submitted that the provisions of section 489A to section 489E were brought into the statute books to deal with various offenses in respect to forged or counterfeit currency notes or bank notes. And the object of the legislature in enacting these provisions is not only to protect the economy of the country, but also to provide adequate protection to the currency notes and bank notes. She submitted that from the materials on record, it is clear, from the evidence adduced, it is clear that the appellant was in possession of the fake currency notes. And this has been duly proved during the course of the proceedings. She therefore submitted, as such huge quantities of fake currency notes were seized, the necessary implication was that the appellant had knowledge that these fake currency notes, were fake and counterfeit. She therefore submitted that there was no error in the impugned judgment for which there is no requirement of an interference. Anything more? This court have heard the learned counsels at length and given its anxious consideration. Before proceeding to deal with the facts of the case, this court would like to take note of the provisions of section 489B and 489C. And the said provisions, for the sake of convenience, are reproduced hereunder. A perusal of the above extracted provisions would show that the mainstay of the offense under section 489B and 489C is knowing or having reasons to believe that the currency notes or bank notes are forged or counterfeit. Without the aforesaid mens rea, selling, buying or receiving from another person, or otherwise trafficking in or using a genuine forged or counterfeit currency or banknotes is not enough to constitute offense under section 489B of the Indian Penal Code. It is also relevant to take note of that possessing or even intending to use any forged or counterfeit currency notes or banknotes is not sufficient to make out a case under 489C in absence of the mens rea noted above. In the backdrop of that, it is relevant to take note of as to what the prosecution have proved. From the evidence so adduced by the prosecution of the 6 witnesses, it would be seen that the prosecution have only proved that the accused oblique the appellant was in possession of the currency notes in question. The prosecution have categorically admitted during the cross-examination that the appellant had simply possessed the seized articles and have also not utilized the seized articles. This aspect of the matter would be clear from the cross-examination part of the prosecution witness number 1. The same, which is extracted here in below, a page 5 or 6 or 7 to quote code. It will also be seen that from the other evidence of the prosecution witnesses, there is not a single shred of evidence to that effect that the appellant had knowledge or had reasons to believe that the currency notes or bank notes are forged or counterfeit. It is very pertinent at this stage to mention that for attracting the provisions of section 489C, B and C, the mens rea of knowing or having reasons to believe that the currency note or bank notes are forged or counterfeit is a sine qua non for attracting the provision of section 489B and 489C. It is further relevant to take note of that the learned trial court also did not at all address this issue, in as much as amongst the points for determination which were framed, there was no reference to that aspect as to whether the appellant, whether the prosecution, whether the appellant oblique the accused had knowledge or had reasons to believe that the counterfeit which was, that the currency notes which were seized were forged or counterfeit. Full stop. And this aspect of the matter also percolates to the examination of the accused oblique the appellant under section 313 of the code, wherein the learned trial court failed even to put that specific question. Under such circumstances, as the prosecution have failed to prove that the appellant herein had knowledge or had reasons to believe that the currency notes were forged or counterfeit, the The conviction of the appellant under section 489B and 489C of the Indian Penal Code cannot be sustained in law. Accordingly, the impugned judgment and order dated 23/2024 passed in
35.
Sessions case K number 35/2019 arising out of Varangati PS case number 38/2017 is set aside and quashed. The appellant herein be set at liberty. What are the other lines there? I don't deliver normally judgment.
Sentence part.
Huh?
Sentence part. Conviction and
It's set aside and quashed.
And the
As
sentence
well and the sentence
dated, my lord.
dated
Dated is 23, my lord.
same date, na?
No, not
Different
so.
date.
No, it is the same.
No, my lord.
Case
Page
passed the
15.
same judgment.
Page 15, your lordship. will
Huh?
see. Date of judgment is 7/3, my lord.
Date of
Conviction,
judgment
yes.
is 7/3.
Yes, my lord. Date of sentence order is 23.
But it is the same judgment.
No,
No, it is a part of it. Same.
no, part of it, but sentence was heard subsequently, my lord.
Huh?
Sentence order. is
Judgment
part-
and order dated. No, it's the same judgment. They have
If your
put it as
lordship will
7/3.
kindly, see page 15, my lord.
Huh?
Page 15, the body of the judges, nowadays the format is given.
Then this is the judgment, page 16.
No, 15, my lord, the judgment starts from page 16, my lord.
Page 16.
Yes.
Then it continues.
Date on which the judgment is up, then date of judgment is 7/3/24, date of sentence order is on 23/24, because he was taken into custody, my lord.
Huh?
He was taken into custody, my lord.
Date of sentencing.
Yes, my lord. It's
The
separately.
judgment and order dated 7/3/2024 is set aside and quashed, as well as the sentence or dated 23/2024 is also set aside and quashed. And then remaining there are line is there, na? He's given the liberties immediately to be released or something.
Yes, my lord. To forfeit if he's not wanted in any other cases.
No, where is that? How do I know? What is that line used?
That the jailer will know, my lord.
Huh?
If he is not wanted in any other case, my lord, then he will be released forthwith, my lord.
Somewhere.
But that is there, my lord. Because custody warrant will be issued, my lord.
What is that line used?
Well, the accused is released forthwith provided he is not wanted in any other cases.
And we set aside the
Yes,
conviction and
conviction and
sentence
sentence.
passed on the appellant under section 489B and 489C and then the conviction and he is set aside and quashed and acquit
consequently the
petition-
sentence.
acquit the accused from the said charge. Huh? Then anything more?
Nothing, madam.
I think this will do.
This is good one.
Then you can
Issues that the custody warrant
But that is to be done by the registry.
by the registry will be.
they will do it
Yes.
from this.
Yes.
I think this will enough.
This is good enough. Much obliged, madam. I get.
Don't deal with criminals.
But has taken out a very fine point, madam. I'm obliged, madam.